And at item number 3, it is also come in chamber. You see about regarding autistic child. It is regarding an sorry. Item number 3. The Lordship see the last order also. From the appearance of the opposite party, it comes in chamber. So let it come in chamber. Okay. Your Lordship the last order and prior to that order also. Your Lordship see that.
Your Lordship, the appearance of the child in person has been dispensed of, owing to the fact that he's an autistic child. Your Lordship, now there is no requirement for this matter to be taken up in the chamber because in the previous order, the court has reflected that the physical appearance of the child is no longer necessary. So now it is the time to determine whether they have the right at all to take the guardianship of the custody of the child, my lord.
We'll take in open court if it is.
Much obliged, Your Lordship.
My lord, how interaction will be taken. See that. This is the petitioner and opposite party.
Let it come. Let it come with you.
My.
Supplementary list, item number 1. I'm filing the memo.
And counsel for the petitioner files a memo to withdraw the writ petition disposed of as withdrawn.
Obliged, my lord. Item 2.
My lord, I pray for a short adjournment. Mr. Mishra, the conducting counsel, is out of station.
This is a habeas corpus petition.
Yes, madam.
No urgency.
My lord, a short adjournment.
Okay, you want it October or November?
Any date.
Yes.
Any date, a short adjournment, any date.
So it will come on 9th October if you say that there is no urgency in a habeas corpus. So let it be adjourned.
No, my lord.
Is this matter?
Premature release of the
Naturally.
premature release of the petitioner from the jail custody.
It's all right too. You also try to obtain instruction. It seems that he is in custody for 23 years.
24 years.
24 years.
2 times it has been rejected.
All right. Is this matter on the prayer of the land council for the petitioners? Is this matter in the we commencing from 25th September 2023? Yes.
It will come on, my lord.
25th September.
Obliged, my lord.
Item 3.
Your Lordship see the last time.
What is the prayer made in this application?
To get the custody of the child.
Please use the mic properly. Yeah.
To for appearance of the child as well as custody.
Who's it is a dispute between the
grandfather and son-in-law.
No. In whose custody the child is now there?
Since his birth, after 1 week of his birth, child is with us. His mother expired when he is present in our house, and thereafter,
who is this Sujata Sethi?
Sujata Sethi is the wife of opposite party number 1. He is not the mother, my lord. His child's mother is dead.
Okay.
Child's mother is dead. He is with his grandfather for till he attains about 5 years.
Grandfather means who?
Wife's father. That means mother's father.
Biological mother's father.
No, it's all right. Who is the petitioner?
Petitioner is the grandfather.
Okay. So that means you want the custody of your grandson.
Yes, ma'am. My lord, I am not exactly. I am in custody for to take the custody of the child for entire. He's improved. He's an autistic child. He's improving to the treatment, and doctors are very hopeful he will be cured by 2-3 years. Now, in spite of that, they have taken the child from us forcibly.
Who has taken the child?
Father.
Father means who? This opposite party number
One.
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 So the child is now staying with his father.
Yes, my lord.
How can it be a illegal detention?
It is not illegal detention.
Then how habeas corpus will be maintained?
My lord, it is not a illegal detention, your lordship.
Unless it is a wrongful detention, or if you want custody, you have alternate remedy with you.
Yes,
You
my lord.
appear before the
My lord, I know the remedy.
there are provisions.
That's why the other bench, my lord, they have stated that what is the paramount child, the paramount.
No, in a Mr. Patnaik, in a writ of habeas corpus, the scope of inquiry is very limited. We can just ascertain by way of affidavit. Once you approach the appropriate court, like family court, file a petition under Guardianship Wards Act or whatever the other provisions, then notice will be issued, and you will get the scope to adduce the evidence. The child will be asked, and the court is to see best interest of the child. We will be served with which custody. All these things.
Your lordship knows how much time it will require.
No. We can once you file the case, and if there is any delay, you can come and appropriate order can be passed.
My lord,
First of all, you file the application. There are number of decisions that in such type of matter, if the writ of court should not entertain unless it's an exceptional one. And now the child is with his father. So we, under no stretch of imagination, we can say that the father has wrongfully confined, illegally detained his own child, and that is the main basis required for entertaining a petition of habeas corpus.
If your lordship go by technicality, your lordship is right. But if your lordship see the paramount interest of the child, that also same thing happens.
No, habeas corpus petition is obviously a technical.
My lord, definitely. This is a technical. If your lordship go by technical, it will take 2-3 years in the lower court.
No. Why 2-3 years? You first file, and if it is delay, first notice will be definitely issued.
Already 8 months has taken, and 8 months have passed.
Where you have 8 months means?
By from out taken.
Have you approached the family court or any court?
No.
How you say that 8 months have passed?
No. 8 months have passed, but taken over the child.
It's all right.
The child, I try to appreciate one thing. The child is with the natural parent.
Yes, ma'am.
That is the
when my natural father goes against the interest of the child.
How do you know? Why should?
That's why investigation. That is why evidence has to be adduced.
That's why child was directed to appear. On that day, they have seen that the child, what sort of thing they have done, what sort of improvement within 3 months. Thereafter, he wants to court wants both parents and.
You see, once Mr. Patnaik, once the father is given opportunity, he may adduce evidence. Sir, look, sir, these are the care which I am taking. If he is ill, I am taking him to the hospital. If he is prosecuting his study in this school, I am taking all care. I am spending huge amount. So those things are to be brought on record for a court, not that we will just see for him 10 to 15 minutes and will adjudicate that whose under whose custody the best interest will be served. It is that's why it's a summary in nature. That
will be at that time it will be more deteriorating the child's condition. That's why the court.
These are the claims and counter claims in the writ jurisdiction. That in habeas corpus petition, you want us.
Mr. Patnaik, would suggest that if you apprehend in that way, you file. We are keeping this matter pending. You file one petition and you say that we have filed. Give the number. We'll direct the family court to expedite it and conclude it within a. We'll also record his submission that he will ensure the appearance within a particular time, and direction will be given to conclude it within 3 months.
That's right, madam.
So please file the petition and bring the number.
Yes, ma'am.
Okay.
I'll do it.
Lordship, just to substantiate our stands, the child is autistic. He's born out of surrogacy. These all facts
all right,
are suppressed.
Let him. All right, let him file.
It will be disposed of in that direction.
No. First, let him file. He is apprehending that there may, and it is not. He is justified in so many cases. It is pending since years together. Unless direction is issued by this court He may not.
What is the prejudice you have? No prejudice.
No
Let him
prejudice,
tell
my
them.
So let him.
But let there be no observation that I am not taking the paramount
No,
importance.
that
of
type
the-
of
Nothing about that. No. Just
obliged,
will
Your Lordship. With
dispose
that
of
observation-
once you file. Like Mr. Kalan Patnaik, land senior advocate, appearing for the petitioner. 6 1 week adjournment. Place this matter in the week commencing from 25th September 2020. We are just keeping it. File the case, bring the number. That's all. We'll do the next. All right.
Much obliged, Your Lordship.
Item number 4.
Right. Can I have a glance to the order dated 4/7/2023?
Four seven.
2023, ma'am. Last order.
Yes. There, a council is supposed to be engaged
Well,
by
I've been
the.
engaged.
You have been engaged.
Right.
Now, the appellant is on bail.
That instruction I have no.
No, from the
He
order
has allowed bail on 13/3/2014.
13/3/2014. Let us see.
Also, Your Lordship directed the IIC details of the appellant's bill.
In that regard, my lord, your lordship may grant a short date because you have already sent a letter calling for his whereabouts and
Right, whether he is alive or
Yes,
not,
yes.
all these things
Yes,
have to be required. It's a 302 case, life imprisonment.
Yes.
Yes, yes.
So you are supposed to get the instruction from Lafripada police station in
Yes,
the
ma'am.
district of Sundargarh,
Yes,
right?
we've already sent letter, my lord. It's gone to Lefripada PS.
Okay, we can take it off on 25th. You obtained the instruction.
Probably 25th.
Okay,
Yes.
the status of the appellant, all right?
Yes, ma'am.
Mr. Amitabh Tripathi, Land Council, submits that he has been engaged by the Orissa High Court Legal Services Committee, Secretary, Orissa High Court Legal Services, to conduct the case on behalf of the appellant. Mrs. Patnaik, Land Council for the Additional Government Advocate for the state, submits that the appellant has been directed to be released on bail by order dated 13/3/2014 in Miss Case number 11 of 2014, and she may be given some time to ascertain the status of the appellant. List this matter in the week commencing from 25th September 2023. Mr. Tripathi, this Satyajit Mahapatra's name is appearing. It will be deleted from the list along with your name, or the Wakalat number.
Not, but I have only appeared, but
Not the Satyajit Mahapatra.
No, previously Satyajit.
The name of Mr. Satyajit Mahapatra shall not be reflected in the cause list henceforth. Okay.
Obliged.
Item number 5.
What is this matter, Mr. Panda?
This is an appeal against conviction, my lords.
Yes.
There are two appellants. Appellant one has been convicted on 302 read with 34 ITC, along with appellant number 2, who has also been separately convicted on 323 ITC.
They are on bail.
They are on bail.
So it's for hearing now.
It's for hearing. What I was saying, if your lordship takes it up day after tomorrow, I'll go through the trial court records.
Yes, we are in the midst of another part-heard
My
matter. So, okay, this is in the, we can take it off. There is no problem in that.
This is in the supplementary list.
Right, it will come on 14th. That is September 14th. So, Mr. Tripathi, you are to argue this matter. So get ready, we'll take up this matter. Heard Mr. Debasis Panda, Land Council for the appellants and Mr. Tripathi, Learned Additional Standing Counsel, on consensus of the parties, place this matter on 14th September 2023 in the supplementary list for hearing. Okay.
Lords, may I pray one thing? I'll give a pen drive, my lords.
Okay.
I may be
The
allowed to take.
Lower court trial court record be supplied to the Mr. Panda on his pen drive. Yeah.
Item 6.
ସେମାନେ ଦେଇଦେବେ ସାଙ୍ଗେ ସାଙ୍ଗେ।
Item 630 in the foremost, may I pray my name to be deleted, my lord.
Okay, Mr. Shashwat Patnaik, Land Counsel appearing for the additional government advocate submits that her name may be deleted from the as the counsel for the appellant. Henceforth, the matter will be listed without indicating the name of Mrs. Shashwat Patnaik. Yes, what is this matter? Who is then?
My lord, Mr. Mishra is out of station now.
So it's a 302 case.
Yes, sir.
So
Live conversation.
how many years of practice you have got?
My lord, few months.
Few months. Then you cannot, because it requires at least 10 years of practice to argue a 302 matter. That is it. So ask Mr. Mishra to get ready and will not adjourn the matter further. It will be added to the next week hearing list. Okay. It's a 2008 matter.
But you can very well assist.
Yes, ma'am.
Get prepared and assist your senior so that you can learn many things. All right. Yes.
Obliged.
So submit that Mr. Mishra has some difficulty, a personal difficulty with this matter. And we commencing from 18th of September 2023.
Item 7.
My lord, next week.
Item 7, my lord, earlier the instruction was sought for about whereabouts of the appellants one.
How many appellants are there?
There are 2 appellants one.
Yes.
Proper,
What is that
one
order
appellant-
dated?
one app-
27, let us see. Non appears for the appellant, the reports so and so.
My lord, next week.
Just a minute. Patience. Reliable learned that appellant is staying at her father's house and so on so. In board notice be issued to the appellant remain present on the next day. Also directed to telephonically inform the in records on. Yes. So what happened? What instruction you have taken?
So far, appellant Purushottam Pradhan is concerned, my lord, appellant number 1
Yeah.
is not available in his house. The address given in the court title is not available in that place.
He's not residing there. He's not residing that.
Not residing at present as per the instruction. And it is also stated that now staying at his father-in-law's house, namely at Pandav Bindhani at village Satranga. Yes, Haramanga, district both. So one instruction should be called for.
No, this Ms. Tripathi has already been engaged by the High Court Legal Services Committee to conduct the case of the appellants.
Yes, ma'am.
And
Yes,
she communicated over telephone message that she is not available. Notice issued to the okay. And what about the other appellant?
there is no instruction, madam.
No, what no instruction? They have been released on bail by this court by order dated. This Purushottam was released on bail on 19/12/2018.
Counsel appearing for the appellant may better, madam.
No, it's a jail criminal appeal.
Yes,
Now suppose they will not show any interest. Of course, he is asking for time. It's all right, but CRP study.
Madam, do you have any information about these appellants? No.
No. Then my elder sister, other court engaged. No, two more, sir. Next week, not 2 more. Yes. 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 Yes, Mr. Sir. Shanti? Very much. Mr. Samachi Shanti. And the population of the answer. First time I see population. My lord, appellant
Mr. Mishra, section 385 CRPC, it says about the procedure for hearing the appeals. So it is stated that so far as hearing is concerned, the appellate court shall cause notice of the time and place at which such appeal will be heard and given to the, if it's a regular appeal, it's a matter is different. But now suppose it's a jail criminal appeal and the counsel is showing no interest who has been engaged by the High Court Legal Aid Committee and they are on bail. I do not know whether both of them are on bail or one is on bail because the order sheet reveals that the appellant Purushottam Pradhan was directed to be released on bail as per order dated 19/12/2018. Whether any order of bail, whether any order of bail has been passed so far as the other appellant is concerned. At least whatever material record available with us, it doesn't indicate that there are two appellants in this because both of them have filed the prisoner's petition for which yes, they have signed the application dated 18/2008. Purushottam Pradhan and Karna Pradhan. So, is there any bail order in for this Karna Pradhan?
Sister appearing for the side of appellant.
Yes, he has got no information. She has got no information. You are asked to last order. You are directed that notice be sent to the said IIC to remain present so and so. To telephonically inform the advocate whose wakalatnama is on record. That's different matter. For Karna Pradhan, there is no bail order. How do you say that he has been released on bail? On what basis?
Purushottam Pradhan.
Purushottam Pradhan, it's all right. There are two
Two appellants.
Right. So we are asking you about the second one who has not been released on bail. So he must be in custody. And Wakalatnama indicates that they were in the Puri jail when they filed Wakalatnama.
Well,
So what is the status of that particular appellant?
I'll take instruction by it.
All right, take down the. What is your present instruction now so far as appellant number 1 is concerned?
And his concern is not available in the address given in the cost settlement.
Okay.
And
And what you have ascertained?
he is staying in a father-in-law's house
That is information instruction given by whom?
by IAC, by Inspector in charge, Gospel PS, my lord.
My lord.
Written instruction.
Yes, ma'am.
Okay, file a copy of the same.
Yes.
The Mr. Mishra and Additional Standing Counsel submits that he has received written instruction dated so and so from IAC Daspala Police Station that the appellant number 1, Purushottam Pradhan, is not residing in village that what is that village Koravari under Daspala Police Station in the district of Nayagarh, but he is staying in his father-in-law's house, and the IAC is taking all steps to serve the notice on him within a week. You serve the notice of the hearing that within a week. It appears that appellant number 2, Karna Pradhan, has not been released on bail by this court during pendency of the appeal. The Land Council for the state shall obtain the status of the appellant number 2, Karna Pradhan, and steps shall also be taken to intimate about the date of hearing, which we fixed to we commencing from 25th September 2023. Free copy of the order be handed over to the Land Council for the state. So, Mr. Mishra, that Wakalatnama was signed from Puri jail. We do not know whether he is there or he has been transferred to some other jail, right?
Yes,
so ascertain it and try to serve the notice of hearing. We are taking off on 25th September, and simultaneously you also write that mention is made on behalf of Miss B.L. Tripathi, Vijayalakshmi Tripathi, take up this matter on some other day. So just one line, and then 25th September for hearing.
Thank you.
Weekly list item number 2.
May I please, Your Worship? With regards 301, my lord, yesterday I searched Manupatra, my lord, and got 2 decisions. So one decision, my lord, not exact 301, but in fact, in that case, my lord, the Honorable Apex Court.
What is the paper book of this item number? এটা কোন ভাগ করছে?
I don't do. Paper
पेपर बुक टा भाई करो ओपन करो No, you just read one eyewitness, then you argue
My-
because
Eyewitness
better.
P-double 3, my lord.
Okay,
Will
PW,
better, my lord.
let us.
P-double 3, accused Mahadeva Kisan,
1 minute. 1 minute.
1 minute. PW3 evidence करो.
page 38, paper book.
PW3 Sukru Kisan.
My lord. My lord. Page evidence. Accused Mahadeva Kisan is my nephew.
Just a minute.
ठीक है, ठीक है.
मनसु केतल आछुंती हां सकाळू आसी कोन करूछंती
Page 38, man. Paper.
Some technical problem. Yes.
Sukru Kisan.
My lord, Sukru Kisan.
Yes, please press.
My accused Mahadeva Kisan is my nephew. This is Natha Kisan is my co-villager. The occurrence took place in the noon 2 years back in the month of Vaishakha. Ganapati was hosting a feast on the bank of a river Sankha by inviting the casteman as he had killed a cow. I was present in the feast along with some other fellow castemen. Accused Mahadev started quarreling with his father Phagu Kisan in the feast. I intervened, leaving his father. Accused Mahadev started quarreling with me. There was a hot exchange of words between me and the accused. The accused threw some dust and sands to the soil the sharp food. Thereafter, he threw the utensils containing curry and left the spot in an angry state. Sometime thereafter, he returned to the spot with a gun. I was standing towards the left side of deceased Natha Kisan. At that time, I close proximity, showing the gun at me. Accused Mahadeva threatened to kill me. Natha Kisan tried to pacify him, but in vain. Accused Mahadeva Kisan fired shot aiming at me. One of the pellet hit right side chest of deceased Natha Kisan and he fell down there. One of the pellet passed near my left ear without hitting me. I lost consciousness for some time. Regaining my sense, I found Natha Kisan dead with a bleeding injury on his chest, and a fellow casteman had tried to tied the accused after snatching the gun from him. Cross-examination. It is not a fact that pellets of the gun went off during tussle between Natha Kisan and Mahadev Kisan. It is not a fact that Natha Kisan was holding the gun after obtaining the same from somewhere in the jungle near the spot. It is not a fact that accused tried to snatch away the gun from Natha Kisan, and in the process, trigger of the gun got pressed, and one of the pellet hit Natha Kisan and another hit the accused. It is not a fact that death of Natha Kisan was accidental. It is not a fact that seeing death of Natha Kisan by gunshot, all of us left the venue of the feast, and police came to the spot on prior information, and during inquiry by police, we falsely implicated the accused Mahadev Kisan through death of the Natha Kisan by accidental. It is not a fact that police detained us for 3 to 4 days in the PS, as we did not hand over the gun to the police. It is not a fact that being afraid of our implication in the case, I am deposing falsely against Mahadev Kisan. It is not a fact that I am deposing falsely against Mahadev Kisan because he, being my nephew, insulted me in the public view before my fellow casteman. That is the case, my lord. But in fact, PW 1 and 2, they stated that when the accused came back from his house with a gun, by the time when he tried to fire at the
but the fact remains that he went off
in the
got
house,
the
my
gun
lord.
and came back.
That is
That fact is consistent.
my lord. That fact is there, my lord. But in fact, the other two witnesses, PW 1 and 2, they claims to be the eyewitness to the occurrence. They stated that the deceased, PW 3 takes shelter behind the deceased. For that reason, the bullet hits on the deceased. But in fact, the
Can't take the shelter because he was in the left side,
my lord,
and the right side.
man,
The bullet
other two witnesses
must be
my lord,
side
that
by
too.
side.
But PW 1 and 2 stated like that, my lord.
Shelter means he must be behind,
My lord.
but it appears.
But the Shukru Kisan not stated like that, my lord. He has to take shelter behind the deceased. And that after PW 4, though the prosecution claimed to be an eyewitness to occurrence, he has not stated anything. He has stated that while at the first instance he went to the house and he came to know, left the feast after taking meal. I do not know what happened thereafter. Later I heard that Mahadev Kisan killed Natha Kisan. So though prosecution claimed the PW 4 was the eyewitness, but he has not stated anything against occurrence.
No, Mr. Rogard,
my lord.
the evidence appears that there was some quarrel
My lord.
between the parties, and the appellant left the spot, and then he returned with a gun, and he was against this PW
Shukru Kisan.
3, right? And to kill him, let us say, to go to that extent. But evidence indicate that the Shukru Kishan stayed in the back of the deceased. So when
as per evidence of PW 1 and 2,
right,
3 the Shukru has not stated like that.
Okay, so that is why when he fired gunshot, it didn't hit the PW 3, but it hit the deceased. So there is no evidence on record that any other person at the spot was having gun except you, right? So the question is that you left the spot during course of quarrel came prepared with a gun and started firing. And it's okay that that didn't hit the person whom you are aiming at. It hit the deceased because that person remained behind the deceased. But question is that whether it would be a case of transfer of malice under section 301 IPC or not.
My lord. For that,
So-
my lord, I have brought a decision, my lord, yesterday. Though private defense is there, but in fact, the Honorable Apex Court, my lord, in paragraph 31,
what is the decision?
decision, my lord, criminal appeal,
No.
appeal criminal,
What is the name of the party?
Kasiram and others versus State of MP.
Just a minute. Kasiram versus
State of MP. Decided on 17/10/2001. 3 judgments, my lord.
You have photocopy of that?
My lord.
I've got the photocopy.
One copy, my lord.
No, it's all right. Is it not reported in any journal?
Manu Patra, my lord.
Manu bhai bahar kolati party now dio.
Kasiram and others
SCC
versus State of
online
MP.
Manu Patra bharta Manu Patra ଦେଇ ନାହାନ୍ତି ଅନ୍ୟ କୋଉ ଜର୍ନାଲରେ ରିପୋର୍ଟ ହେଇଛି ଦିଆ ହେଇନି
ଦେଇଛନ୍ତି।
ମନପତ୍ର ତଳେ ଲେଖା ହେଇଥିବ
AR 2001 Supreme Court 2902
ଆଣ ସେଟା
AR 2001
ଏଇଠି ବାହାର କର ଆଉ SCC ର ରେଫରେନ୍ସ ଅଛି କି ତା ଦେହରେ
ଆଜ୍ଞା
ଦିଅ ଏଇଠି ବାହାର କର ସାଇଟେସନ ବାହାର କର ଫାଇଣ୍ଡ ବାଇ ସାଇଟେସନ ଏଇଟା ନିଅ ସେଟା କଣ ନାଇଁ ଉପରେ ଫାଇଣ୍ଡ ବାଇ ସାଇଟେସନ ଇଆଡେ ହଁ ଯୋଉଟା ଏମିତି
କୁହନ୍ତୁ ସାଇଟେସନ କୁହନ୍ତୁ
କାଶୀରାମ KSHI ରାମ and others
ସାଇଟେସନ କୁହନ୍ତୁ SCC ସାଇଟେସନ
AR ଟା ଅଛି SCC ନାହିଁ
SCC ବି ଥିବ ସେଇଠି
CCR ଅଛି
Okay, we'll quantify find by party name. Yes, select court is Supreme
party name
Court.
କରିଦେଲା
କାଶୀରାମ
Spelling କଣ
KSHI
ମାର
RAM
just a minute K A ଦେଖିକି ନି टाइप करो
KSHI K काश्मीर KSHI काशीराम
ଆସିଲାଣି ତଳେ
and others versus State of MP. But 3 judgments
and others
versus State of MP.
ଗ୍ୟାପ ଦିଅ
କାଶୀରାମ ଗ୍ୟାପ ଅଛି ନା ଗୋଟେ ୱାର୍ଡ
ଗ୍ୟାପ ଅଛି ରାମ ବଡାର କ୍ୟାପିଟାଲ
CPC କୁ ଡାକିବ ତମେ ସବୁ କଣ ଟ୍ରେନିଂ କିଛି ଦିଅ କାଶୀରାମ versus
State of MP. Decided 17/10/2001.
Why are you not bringing out that AR?
AR, my lord, 2001 Supreme Court.
जाओ तुम AR?
AR Supreme Court, 2001 Supreme Court, 2902.
What has been held there? Please read it out.
Paragraph 31.
Okay.
The only accused whose acts need to be determined for the purpose of finding out what offense, if any, he has committed. Any accused is accused Ramesh. Exception 2 to section 300 IPC provides that culpable homicide is not murder if the offender, in exercise his good faith of a right of private defense of a person or a property, exceeds the power given to him by law and causes the death of a person against whom he has exercised such right of defense without premeditation and without any intention of doing more harm than necessary for the purpose of such defense. We have found the deceased Brindwal having sustained injury by gunshot fire by the accused Ramesh. Such injury was caused when the members of the prosecution party were fleeing away through to being with the accused Ramesh had available to him the right of private defense of person. The right was exceeded. Therefore, the act of accused Ramesh would be covered by exception 2 to section 300 IPC. The injury caused by Brindawal shows the pellets having injured lower part of the body of a Brindawal. It cannot be said that the accused Ramesh intended to cause death or cause such bodily injury as was likely to cause death, though he should be attributed with the knowledge that the injury caused by him was likely to cause death. His individual act of causing injury to deceased Brindawal is therefore punishable under section 304 part 2. So also his subsequent firearm at a complaint Sundra, but the accidentally hit Jamuna Bai Dhawan would also be punishable under section 304 part 2 of the IPC with the aid of section 301 of IPC. If he had injured the complainant Sundra, he would have been liable to be convicted under section 304 part 2 of IPC. In spite of complainant Sundre alias Sundra having escaped unhurt, and yet Jamuna Bai Dhawan having been injured, though not aimed at, on the doctrine of transferred malice, as contained in section 301 of IPC, is liable to be accused remains the same. In the affair, the version of Sundra was that Jamuna Bai had intervened to rescue him when he got injured. This story was abandoned by the Sundra and whilst in the witness box, and maintained that though the second shot by accused Ramesh was aimed at him, it hit Jamuna Bai instead of him. No prosecution witnesses stated where the gun held by accused Ramesh was aiming at the prosecution version. Coming through the three eyewitnesses that accused Ramesh has a standing posture facing them when he fired the gun is not supported by, rather belied by medical evidence. The fact remains that Jamuna Bai was neither aimed at nor intended to be harmed by accused Ramesh. In case of accidental injury, attracting applicability of a transfer of malice under section 301 IPC, having held that the act of the accused was covered by section 304 IPC, the court should lean in favor of the convict, the accused under part 2 of 304 if it is doubt as to which one of the two part of the section 304 IPC would be attracted. It would be consistent with the basic intent of extending benefit of doubt in criminal jurisprudence. Accordingly, we hold accused Ramesh guilty under section 304 part 2 for causing death to the Jamuna Bai. And here the case, my lord, he aimed at another Sundres, but hit on the Jamuna Bai. For that reason, after court, my lord, taking into consideration 301 and others, my lord.
No, suppose
my lord,
it would have hit the right person
my lord,
against whom he had intention or he was targeting. He would have gone with him right from the beginning. So there was a quarrel and he brought out the gun and fired at him. Okay. Matter is different. You can say that exception 4 is there. Question is here, he is leaving the spot. Okay. During quarrel, he leaving the spot, coming prepared to the spot with a gun. That makes the difference. In most of the cases, we'll found that during quarrel, he picked up something from the spot, gives a single blow. Or he was having a weapon with him during the quarrel, a sudden quarrel on account of provocation, stabs him, give a single blow. Matter is different. But when it says that, because the law, it said that there was no premeditation. Premeditation, it is not there. He acted all on a sudden due to grave and sudden provocation. That is why they are bringing it within exception 4 and taking it to either 304 part 1 or part 2, right? But here is a case during quarrel, you leave the spot,
again come
you
back.
made up the mind, bring the gun, then came to the spot, then you started the assault or firing.
My lord.
You are firing at one, but it hit at another.
My lord.
Again, same thing. He says that whether it hit A or it hit B, it is immaterial. Once you have intention to kill A and fired, merely because it did not hit A, it hit B.
B.
It doesn't mean that you will not liable to for punishment because it hit B.
My lord.
That is why this transfer of malice
My lord.
was there in 301. So we
And
have
your
that.
intention in so far as to kill Sukru is
My
very
lord.
clear.
They're
You
very
can't
clear.
dispute that
My
part.
lord.
If you can't dispute that part,
My lord.
then it hit to
Another.
Natu.
My lord. But here this case, my lord, I have a citation, my lord. This case, my lord, there are two parts of occurrence, my lord. Two persons killed in that case, my lord. So for the second part is when the persons, my lord, went away. By the time the petitioner or the appellant in
Now,
that case,
question, Mister, you are leaving one thing.
my lord. I know, my lord. He entered into the again, my lord, came to the house and
No. Suppose let us say that he went to the house,
my lord.
bring the gun with him. Is there any material that he was a expert in shooting?
সেটা মনে করছেন উইটনেস মনে করছেন
So there is no
no
material.
no material.
So when he fired, whether his intention that I will be sure that it will hit on the chest of the deceased.
That is that part not.
So that part is not there. How can you say that he fired because with an intention to kill?
Yeah, evidence has come. It was specific question was put in the cross examination, and he says that neither of us know how to operate a gun.
Only Sarpanch having a license gun and he know the firing,
So
but the
somebody came with a gun and fired,
My lord.
and it accidentally hit the chest of that person,
My lord.
right?
My lord.
So can it be said that he had intended to kill, that he aimed at that particular point?
That
He was
is
a shooter
My lord.
like that.
He's
That's
a
a
sharp
matter.
shooter,
but
something
the
like that.
P.2
They are
specifically
like
stated,
the
P.2 specifically stated, except that Sarpanch who was having a gun, no other persons, my lord, know how to fire, my lord.
very thin line
My
are
lord.
to be seen in such
My
type
lord, my
of
lord.
cases that what is to be, how it is to be placed. So somebody, a shooter, and he is firing, you can say yes, he is an expert. But if it is not there, how can you
P.2 my lord, P.2 page 36, my lord, paper book.
SCC ଅଛି କି? 2007 SCC ଦିଅନ୍ତୁ 14. ଏଠୁ ଖୋଲ.
I may be pardoned, my lord.
Yeah.
May I come in, my lord, for
Yes.
assistance, my lord, with your lordship's permission. My lord, jota apar pachochan the first part, the time the provocation with the act with the time limit that has been decided in Nanavati's case, my lord. In Nanavati case, his wife confessed that she's having an affair with one Prem Ahuja, and then he gets outraged, goes back to the ship, gets the revolver with the bullets, comes back, goes to the house of the deceased, and there he commits the murder.
He's an army man. How can you compare with the villager?
Army man, the
That's why I'm asking you whether he was an expert in shooting. You cannot compare a army man.
The fact that he was agitated and he went back and he has come back.
No, that is a time
period.
You say that.
He had sufficient time to cool down.
I do not know how to use
The
a
accused also doesn't know how to use a gun. That is the evidence.
Evidence is
No, not on the shooter
that
part.
in the cross examination.
Time period part.
এটা কোন তুমি করছো? You do not know how to open SCC online. Huh? It's strange. Type it. 2007. বহি বাহার কর আনো 2007 volume 14 SCC page 660. 660. Keep your eyes open. Be alert. Vinit Kumar. Two paragraphs are entered. Paragraph 16 and 17. 17, let us first read it. We are reading in this decision 17, paragraph number 17. Reverting to the facts in hand, then we'll go to 16. As noted above, it stands to prove that there being a direct causal connection between the hitting of the bullet fired by the appellant to the deceased and her death. The death of the deceased was caused by the appellant. However, having regard to the circumstances briefly enumerated above, particularly the manner in which the appellant fired the shots, and in our view, the appellant could not be attributed the mens rea requisite for bringing the case under the clause of section 300 IPC. Consideredly, this is most important, there was no enmity between the parties. There is no allegation of the prosecution that before the occurrence, the appellant had premeditated the crime of murder. We are not inclined to think that having faced some sort of hostile attitude from the family of the deceased over the cable connection, a sudden quarrel took place between the appellant and the son of the deceased. On account of heat of passion, the appellant went home, took out his father's revolver, and started firing indiscriminately. And unfortunately, one of the bullets hit the deceased on her chin. At the most, it can be said that he had knowledge that the use of revolver was likely to cause death. As such, the present case would fall within the third clause of section 299, and thus, in our opinion, the offense committed by the appellant was only culpable homicide, not amounting to murder. Under this circumstance, we are inclined to bring down the offense from the first degree of murder to culpable homicide not amounting to murder, punishable under the second part of section 304 IPC. Consequently, we partly allow the appeal, set aside the conviction of the appellant under section 302 and instead convict him under 304 part 2 of the Indian Penal Code. And the reason has been given in the previous paragraph. The academic distinction between murder and culpable homicide not amounting to murder has been vividly brought out by this court in state of MP and so on, so where it has been observed that the safest way of approach to the interpretation and application of section 299 and 300 is to keep focus on the keywords used in various clauses of the said sections, minutely comparing each of the clauses of section 299 and 300 IPC and drawing support from the decision of this court in so and so, neatly brought out the points of distinction between the two offenses, which have been time and again reiterated. Having done so, the court said that whenever the court is confronted with the question whether the offense is murder or culpable homicide not amounting to murder, on the facts of the case, it will be convenient for it to approach the problem in 3 stages. The question to be considered at the first stage would be whether the accused has done an act by doing which he has caused the death of another. Proof of such causal connection between the act of the accused and the death leads to the second stage for considering whether that act of the accused amounts to culpable homicide as defined in section 299. If the answer to this question is prima facie found to be in affirmative, the stage for considering the operation of section 300 IPC is reached. This is the stage at which the court should determine whether the facts proved by the prosecution bring the case within the ambit of any of the four clauses of the definition of murder contained in section 300. If the answer to this question is in negative, the offense would be culpable homicide not amounting to murder, punishable under the first or the second part of section 304, depending respectively whether the second and third clause of section 299 is applicable. If this question is found in positive, but the case comes within any of the exceptions enumerated under section 300, the offense would still be culpable homicide not amounting to murder, punishable under section first part of section 304. It was, however, clarified that these are only broad guidelines to facilitate the task of the court and not cast iron imperative. So what has happened in this case, which we find in your favor, is that there was an altercation. Okay.
Well.
Then you leave that place. Okay. Then you came to the spot with a gun. That is the third one.
Well.
Fourth one, you do not know how to operate the gun. Okay.
Well.
That is the fourth one. So you are not aiming at the person to whom ultimately the bullet hit.
Well.
Right. That is, and it is I think it is a single shot. Nobody has said that it is repeatedly done by you.
Once.
Right.
Well.
So in such a situation, that is why we are harping since yesterday that whether the leaving the spot and coming to the spot with the gun would take away 304 part 2 or not. This decision says that no, it can also be 304 part 2 because nobody knows that how much time one would remain under provocation. Okay, it is not the straitjacket formula that once you there was a sudden quarrel, this man or a person would remain under provocation or he would act out of that for a particular period, maybe that it is for 5 minutes, 10 minutes, and if it goes beyond that, it will not be there. One case is there when a seed was thrown on the face of a person, and that matter was reported, and he faced the trial. The accused who threw the acid faced the trial, and he was convicted. Then he was sentenced for some imprisonment. So when he came out of the jail after being released on bail, the injured, that means the person whose face has been disfigured, he fired gunshot at that person and killed him. That man was killed. Single gunshot injury. So there the question came that whether it can be said that it is a case of provocation because so many years have passed in the meantime between the act which has been done by the deceased in throwing acid at the appellant. So they said that every morning or every time he would be looking at the mirror, he would be getting provoked that this man has spoiled my life. So in such a situation, when he saw him for the first time after being released on bail, he might have got provoked and he fired at him. So they brought it that no, it can be a case of provocation. Why we are saying that? You cannot say that the provocation merely because he left that spot, there would be no provocation. He might have acted. It depends upon person to person. Somebody would take time to cool down very shortly. Somebody would take even days together. Somebody may took years together for a particular incident. He may keep that in mind. Oh, I'll. So it depends upon the
Also
person
react
to person.
differently.
React differently.
Differently.
What you will do, that will. So
Maybe the
here,
time limit is also important, my lord.
right. It's not that it. In this case, it is not that a big time gap is there. He just went and bring that. And you see the background. Everybody was invited to the feast. This man was left out. So his grievance is that if everybody was being invited, what offense I have committed? Why? On this issue, there was a quarrel. And perhaps he was humiliated and he left the spot and got that. So these words are very important. You come to that PW1.
My lord.
Please read it once again. Let us see.
This is Natha Kisan, was my father. Accused Mahadev Kisan is my co-villager. I know him. The occurrence took place at 12 o'clock in the noon 2 years back in the summer season. Ganapati Kisan is my younger brother. Myself, my father and my brother were living in joint mess. Ganapati Kisan had killed an ox. For that reason, he was hosting a feast on the bank of a river Sankha at the relevant time of occurrence. About 30 to 35 persons of our caste were present in the feast. We all were sitting to take our meal. At that time, accused Mahadev Kisan raised commotion on the issue of serving of meat curry to him. Sukur Kisan, elder brother of the father of Mahadev, intervened and tried to dissuade accused Mahadev Kisan from his indulgence of quarreling for nothing. There is a hot exchange of words between Sukur Kisan and Mahadev Kisan. Mahadev Kisan left the spot of the feast and returned there after some time with a gun. He threatened Sukur Kisan to fire at him. Sukur Kisan ran and took shelter behind the back of my father Natha Kisan. My father Natha Kisan tried to pacify accused Mahadev Kisan. Without paying heed to the words of my father, accused Mahadev Kisan fired at Sukur Kisan. The bullet hit right side chest of my father and he fell down on the ground, died instantaneously. The persons present there overpowered the accused Mahadev Kisan and kept him in captivity till arrival of the police. Myself, Vishnu Kisan, Parameshwar Kisan went to the PS. I lodged oral report in the PS.
Then now we come to this particular part. Let us come to that PW2. He was also an eyewitness, right? Let us see what he has stated.
PW2. This is Natha Kisan and accused Mahadev Kisan are my co-villagers. I know them. The occurrence took place at about 12 o'clock in the noon 2 years back in the summer season on the bank of a river Sankha. Ganapati Kisan was hosting a feast on the river bank. 30 to 35 persons were present in the feast. There was a hot exchange of words between Sukur Kisan and Mahadev Kisan. When the feast was on, Mahadev Kisan threatened Sukur Kisan to kill. Sukur Kisan also replied in similar tone. All on sudden, accused Mahadev Kisan rose from his seat, threw dust and sand to the prepared food kept for serving and left the spot. After a short while, he came to the spot.
This is not stated by PW1.
Not stated by PW1.
Dust part.
My lord.
Okay.
After a short while, he came to the spot with a gun and threatened Sukur Kisan to kill. Sukur Kisan went to hide himself behind the back of Natha Kisan. Natha Kisan tried to pacify accused Mahadev, but in vain. Accused Mahadev fired gun aiming to Sukur Kisan. The bullet hit right side chest of Natha Kisan and he died there. I accompanied Srivastava Kisan to the PS. After the incident, all of us overpowered Mahadev Kisan and tried him till arrival of the police. The gun was at the spot after being snatched from the accused. who received the gun at the spot in my presence. Parameswar Kisan was also present at the time of seizure of the gun. Exhibit 1 is the seizure list. To that effect, wherein exhibit 1 by 1 is my signature. I cannot identify the gun now. So when the gun was not produced in the court, inquest over the dead body of an S.K. Kisan was held in my presence. Exhibit 2 is the inquest report, wherein exhibit 2 by 1
why gun was not produced? It was left at the spot.
Left at spot. So far the evidence was that
gun has been marked as MO1. Why are you telling that?
It is stated that in the evidence, I cannot identify the gun now.
It's all right, but it has been produced in, it has been marked as a material object.
MO1.
That is page 19 of the paper book.
So far, PDOL 2 is statement, my lord, that had not gone, not shown to him.
No, that's a different. That gun was not shown to.
My lord. During his examination. But his cross-examination.
Okay, then
PW 3.
PW 3. Yes. Which line you want to rely?
My lord, he has not stated a text alter behind the disease. This in S.K. Kisan is my co-villager. The occurrence took place in the noon 2 years back in the month of Vaishakha. Ganapati was hosting a feast on the bank river of Sankha by inviting the castman, as he had killed a cow, as present in the feast along with some other fellow castman. Accused Mahadeve started quarreling with the father Saahoo Kisan in the feast. I intervened. Another story, my lord, he introduced that the accused quarreled with his father. The PDOL 3, another, my lord, introduced another story, my lord. Accused Mahadeva started quarreling with his father Saahoo Kisan in the feast. I intervened. Leaving his father, accused Mahadeva Kisan started quarreling with me. There was a hot exchange of water between me and the accused. The accused threw some dust and sands to the soil to the served food. Thereafter, he threw the utensils containing curry and left the spot in an angry state. Sometime thereafter, he returned to the spot with a gun. I was standing towards the left side of the deceased. S.K. Kisan at that time in close proximity.
Read Ganapati Kisan. Ganapati Kisan was throwing the party. What does he say?
Ganapati Kisan. 6, PDOL 6.
Yes, 6.
This is my father. I know the accused. About a year back, on one day at about 3 p.m. Time alert extended.
3 p.m.
All are set 12 noon.
12 p.m.
Accused shot my father with a gun while myself and the other, including my father, were enjoying the feast on the river bank. Rama, Lakshmana, Sukru, Jayadeva, and other witnesses witnessed the incident. Accused shot one as a result, my father sustained injury on his chest and died at the spot. He had not stated anything, my lord, with regards to.
We are asking you a question about those pellets. That please come to the postmortem doctor.
PDOL 8.
Right. He found the exit wounds also.
My lord.
Right.
My lord.
Pellets were recovered. Pellets were recovered.
The pellets are not recovered, but in fact the cap and other materials, my lord, that has been recovered.
Blanket.
The powder and a coil and cap.
What the IO was sent to the for C examination, that gun was sent. Then aluminum caps marked as B and 32 numbers of pellets marked as C. Let us confine to these three. where from the IO got these materials? This gone. So let us come to the evidence of the IO. IO is PW10, na?
9, 10, 11. 3 jana ଅଛନ୍ତି main
10,
10 ହେଲା main
10 is the main IO.
Yeah, who went to the spot immediately out of these three?
PW10.
10
10 went.
Right. Please come to the
10.
evidence of PW10.
on 16 page 54
Right.
on 16/4/99 I was the OIC Kisinda PS. On that day at about 6:45 p.m. I reduced the oral report lodged by Sivascha Kisan into writing. This is the said report marked Exhibit 7. This is my endorsement thereon marked as Exhibit 7/1. After scribing, read over the report to the informant and when thereafter put LTI thereon. This is the formal FIR.
Come to Para 3 state.
3.
On the
same day, at about 8 p.m., I visited the spot that is Dedra near village Dedra on the bank of river Sanko and found the dead body of Natha Kisan was lying there and a gun and a cotton bag were also lying there and cooking materials, namely the food served but not eaten, accused was also found lying on the cotton being
So that gun was lying at the spot, right?
spot, my lord.
Okay. So that was seized in the next paragraph. It is stated that he seized last 3 lines of paragraph 4 in that very page 55. Collected the blood stained earth, sample earth, country made gone, 11 number of so-and-so, 32 numbers of lead so-and-so, bottle containing explosive, 1 bottle containing so-and-so. So these were all seized and that was sent for ballistic expert's opinion.
That is Exhibit 15.
Huh?
Exhibit 15 is the SFS report.
Okay, and what is the report says?
My lordship, kindly come to page 9 of the judgment, your lordship, para 9.
No, the report is there.
Yes, he has given it.
Page 65, come to that page 65. Result of the examination. So, A. Yes, page 66.
Yes, your lordship.
66. 66 re to seconds of para. The exhibit marked as A which is a country made gonta. Right. Is a country made SBML gun having all essential parts of firearm such as trigger, trigger guard, nipple, hammer, barrel, stock, etc. On examination, it is found that the above mentioned gun is in a working condition and capable of discharging projectiles. So this is a firearm as defined under the Arms Act. Okay. Then chemical examination of the barrel, washing of the above so revealed the presence of gunpowder residue, showing that the gun has been used for firing. Okay. The exhibits marked as 11 number of aluminum cap, they can be used as caps for preparing which are usually used in ML guns. Exhibit marked as The exhibits marked as 32 numbers of lead pellets used as are the reloaded cartridge.
Where from these 32 pellets were recovered?
From a bag, my lord. There, my lord, the IO stated that the gun and a bag was lying there.
Unused pellets.
Unused pellets. Bag containing all the pellets. Nobody stated that how that bag mallet came to the spot, whether the accused carrying or not.
No, nobody has stated you are carrying that. You came only with a gun.
Gun,
That is
my
the
lord.
consistent
My
evidence
lord.
of all the
That is the
eyewitnesses.
case, my lord. Entry window and exit window ଅଛି ସେ ଖୋକାଟା କୁଆଡେ ଗଲା ଦେବି
But
ୟୁଜ ଖୋକା ସେଟା ପାଇନା
otherwise it could have been detected inside the body and shell.
body. One small bottle contains
once after judgment man he has custody when released the Supreme Court granted him bail by the time he had 6 years and 6 months prior to during trial he was a bail prior to that he has been also he was in jail my lord as a UTP total
No.
7 years my lord around
Yes,
7
Mr.
years
Tripathi, what do you say?
My lord, in this case, the lordship knows the fact, lordship. Till then, I'm returning the fact. There was a feast going on there, my lord, and there was a quarrel between the deceased and the accused, your lordship. This is sorry, the PW3 and the accused, my lord.
Right.
And thereafter, he went on and came with a gun and fired from a place for 1 meter to 1 meter, which the PW8 has said.
PW8, let
Yes,
us see.
the doctor has said it, man.
No, doctor says
It is within 1 to 3 meters.
but your witness is also silent.
Witness
That
is
it was
silent during deposition. Only at the time of FIR he has said, as your lordship knows, my lord, that is
in the
section 25 because it is a 161.
in the FIR it is stated 30 feet distance.
Yes, my lord. But in deposition he has not stated anything.
Let us come to that particular line which since you are submitting thila je
FIR ରେ
FIR
23 page 23
page 23
ଖାଇ ବସିଥିବା ଜାଗା ପାଖକୁ ମହାଦେବ କିଷାନ ଉତ୍ୟକ୍ତ ଅବସ୍ଥାରେ ଆସି ପ୍ରାୟ 30 ଫୁଟ ଦୂରରେ ଠିଆ ହୋଇ ଶୁକ୍ର କିଷାନକୁ ମାରିଦେଇ
କୋଉ ଜାଗାରେ ପଡୁଛନ୍ତି
ପେଜ 23 ର 7 ନମ୍ବର ପାରା 79 ଲାଷ୍ଟ ଆଡୁ
1 2 3 4 5 6 7 ନାଇଁ ତ କିଛି ନାହିଁ
ମାନେ ପେଜ 23
ରେ ଉପର ଆଡୁ ନା ତଳ
ତଳ ଆଡୁ
1 2 3 4 5 6
7 ନମ୍ବର ପାରାରେ ଅଛି ଲେଖାଇଛି
ଆଚ୍ଛା ତାପରେ ଆମେ ଖାଇ ବସିଥିବା ଜାଗା ପାଖକୁ ମହାଦେବ କିଷାନ ମହାଦେବ କିଷାନ means appellant, right? ଉତ୍ତ୍ୟକ୍ତ ଅବସ୍ଥାରେ ଆସି ପ୍ରାୟ 30 ଫୁଟ ଦୂରରେ ଠିଆ ହୋଇ ଶୁକ୍ର କିଷାନକୁ ମାରିଦେବ ବୋଲି ଧମକ ଦେଲା ଏହା ଦେଖି ମୋର ବାପା ନାଥ କିଷାନ ଖାଇ ବସିଥିବା ଜାଗାରେ ଠିଆ ହୋଇ ମହାଦେବ କିଷାନକୁ ବୁଝାଇବାକୁ ଚେଷ୍ଟା କଲା କିନ୍ତୁ ମହାଦେବ କିଷାନ ରାଗି ଯାଇ ମୋର ବାପା ନାଥ କିଷାନ ଧରିଥିବା ବନ୍ଧୁକରେ ସେଠି ଫୁଟାଇ ଦେଲା ଫଳରେ ମୋର ବାପାର ଡାହାଣ ହାତ କୁଆରେ ବାଜି ମୋର ଶ୍ୱାନ ସୋ 30 ଫୁଟ ଯଦି ଡିଷ୍ଟାନ୍ସ ଟା ହେଇଥିବ ତାହେଲେ obviously ସେଠୁ ଯଦି ଆମେ କ୍ୟାଲକୁଲେଟ କରିବୁ that will come to 8 portion ପର୍ଯ୍ୟନ୍ତ ଆସିବ ବେଶୀ 5 ଫୁଟ ଏଟା ବେଶୀ maybe from ସେ ପର୍ଯ୍ୟନ୍ତ
but one evidence says that 2 to 3 feet
That is the
That is
doctor
doctor's
stated in his chief, my lord. Cross-examination or doctor denied that, my lord. In the cross-examination, I'm stating, in the cross-examination, my lord,
This is 1 to 2 feet.
I have not mentioned about the gunshot distance in my report.
No, that is why we
That
are.
question, for that reason, put that question, my lord,
Sir,
the defense counsel.
The problem is that the counsel who conducted the case,
Not good.
they must, he should have put the specific question
My lord,
to this informant, and he should
My
have stick that
my lord,
you should have bring the distance to 30 feet.
my lord.
କାରଣ 30 feet range ରେ ଯଦି firing କରିବ ତାହେଲେ ଏ injury ହେଇପାରିବ ନାହିଁ
ନାହିଁ।
କାରଣ doctor ସେଠି what the doctor has seen, you come to that, the doctor has seen that it is blackening, that जो entry wound ଟା blackening ହେଇଛି ବା charred ହେଇଛି, it indicates that it was fired from a very close range. That is how in medical jurisprudence रे कहूଛି तमे केमिति डिटेक्ट करिवो दे ए जो फायर जे फायर कला से प्राय केते डिस्टेंस रे थिला क्लोज रेंज रे फायर हेले बेले बेले से केस हुए नि जे आमे एटा होची जे सेटा सुइसाइड कर दला निजे पॉइंट रेंज सेठी जदी जने एमती रखिन मारिबो ना एठी से ब्लैकेनिंग हबो चार्ट हबो सेठी जदि दूररू मारिबो से ब्लैकेनिंग आसीबो ना so that is how they have stated in Modi jurisprudence also it is there तेणु एठी जा जणा पड़ुछि एठी क्लोज रेंज रु फायर ହେଇଛି कारण एंट्री उनटा देखुछि चार्ड ହେଇଛି ब्लैकेन ହେଇଛି से देखिले से मोदी jurisprudence से particular
Even inquest report also reveals that
what
in the blackening also.
blackening एटा क्लोज रेंज रु
That is
फायर
the judgment matter.
तेणु एटा आपणकर आनिबा कथा डिस्टेंस नै आसीबा कथा थिला डिफेंस से जो आनिथिले could have known that it is not possible medical evidence goes contrary to the oral evidence eta ani parthante apon
What have you said in 313?
Yes, only denial.
Only denial.
This see para 13 of the judgment, trial court judgment.
On transport, the judgment of Japal Singh. Judgment, that judgment, and 1991.
Decline to give the benefit of 3-0. Transfer of my right.
तो जो also in the chapter का मतलब काढ़ी देंगे है ना judgment take down JCRLA number 90 of 2005. Mahadev Kishan versus State of Orissa.
I beg your pardon, madam. So
Yes.
for 301 is concerned, I have to
Give the reasons.
one is Japal Singh and others, and another is your
Pass on.
Rajveer Singh.
The appellant Mahadev Kishan faced trial.
Same Dinesh Kumar. Same Dinesh Kumar. Which
Another is Rajveer Singh.
In the court of Additional Session Judge Sambalpur in session trial number 318/1 of 1999-2000 for offences punishable under section 302 of the Indian Penal Code on the accusation that on 16th April 1999 at 2:30 p.m. in village Dadra Tapu, he committed murder of Natha Kishan, bracket hereafter the deceased, by shooting him with a country-made gun. He was also charged under section 25 and 27 of the Arms Act on the accusation that he was found possession of a country-made gun in contravention of the provisions of Arms Act and used the gun in committing murder of the deceased. The Learning Trial Court though acquitted the appellant of the charge under section 25 of the Arms Act, but found him guilty under section 302 of the Indian Penal Code and section 27 of the Arms Act, and sentenced him to undergo imprisonment for life and to pay a fine of rupees 10,000 in default to undergo RI for 6 months under section 302 IPC, and further sentenced him to undergo RI for 3 years and to pay a fine of rupees 2,000 in default to undergo RI for 2 years under section 27 of the Arms Act. Both the sentences were directed to run concurrently. The prosecution case, as per the first information report lodged by PW1 Srivatsha Kisan before the inspector in charge of Kisinda police station on 16/4/1999 is that in the month of Shravana in the year 1999, the younger brother of the informant, namely Ganapati Kisan, bracket PW6, found the carcass of a bullock in his lands, for which, as per the custom prevailed in the caste, he was supposed to give a feast to the caste members, and accordingly, a feast was organized on 16/4/1999. And caste people of the informant were attending the feast. At about 2:30 p.m., while about 30 persons were taking feast, the appellant there was quarrel between the appellant and his elder father, Sukru Kishan, bracket PW3. PW5 Parameshwar Kisan was present there, forbade the appellant to quarrel with PW3. But the appellant, without listening to PW5, in an angry mood, left this place threw dust in the cooked foods and left the place. After some time, he came back holding a gun and shouted at the persons who were attending the feast to kill them. The appellant stood at a distance of 30 feet away from the place where the persons were taking their food in a sitting position and threatened all of them, and looking at this, the deceased, who is the father of the informant, stood up and tried to convince the appellant However, the appellant fired gunshot which hit the deceased at the right side chest, as a result of which he fell down on the ground and died. Looking at this, The informant and the other persons were present at the feast. Got hold of the informant and took away the gun from his possession.
Got hold of the accused.
Appellant took away the gun from the appellant and kept him under captive position, and the informant came to the police station to lodge the FIR. Stop. On the basis of such written report, Kisinda PS case number 8 dated 16/4/1999 was registered under section 302 IPC and section 25 of the Arms Act against the appellant. अच्छा, से जो written report था ताको कर दिया हम came to the reported orally before PW10, the officer in charge of Kisinda police station, which was reduced to writing. Hala? Then it's all right. PW10 YC like them, YC of so. After registration of the case, took up investigation, and during course of investigation, he examined the informant and other witnesses, deputed the home guards for guarding the spot and the dead body, and sent requisition for services of the scientific team. On the very day at about 8 p.m., he visited the spot, found the dead body of the deceased lying there, and a gun and a cotton bag were also lying there, apart from the cooking materials. And the food which remained unserved, which was not eaten, which was not consumed. Hello? The appellant was also found lying on a cot in an injured condition and was being detained by the villagers. The appellant was sent to Girish Chandra PHC on police requisition for his medical examination, and since darkness prevailed, the inquest over the dead body could not be conducted, and on the next day, that is on 17/4/1999, the IO bracketary PW10 revisited the spot in the morning hours, prepared the spot map, held inquest over the dead body, prepared the inquest report, Exhibit 2. The scientific team also visited the spot, took photographs, and collected Plotston earth sample, country-made gun, empty caps, lead balls, etc. from the spot. And after seizure, the exhibits were sealed and a seizure list was prepared by PW10. The dead body was sent to Subdivisional Hospital, Redakol, for post-mortem examination. The IO also seized the cooking utensils at the spot and on 24/99 he seized the wearing apparels of the deceased. When it was produced by the escorting constable along with command certificate, the appellant was arrested on 21/4/1999 and he was forwarded to on 21/5/1999. PW10 handed over the charge of investigation
PW11.
to PW11. No?
11, my lord. Krishna Chandra Acharya, my lord.
To PW11, Krishna Chandra Acharya, ASI of Police, attached to Kisinda Police Station. And he collected the post-mortem report and thereafter delivered the charge of investigation to SI Bharat Pradhan,
PW9.
bracketed PW9, who seized the bedded ticket of the appellant from District Headquarters Hospital, Sambalpur, examined some witnesses and freed before the learned SDGM Redakol for sending the material objects to RFSL Sambalpur. And on completion of investigation, submitted charge sheet against the appellant under section 302. charge sheet को 302 देखिए ये फाइनल फॉर्म টা देखिए
25, 27 arms charge ಆಯ್ತಲ್ಲ charge sheet
ನಾನು ಚಾರ್ಜ್ ಕೊಡೋದಲ್ಲ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ एक साइड एपट रोटर तोड़गा और तोड़गा summons witness charge sheet FR पर charge sheet होएगा था किसी systematic way रे किसी रखना. This is the final form. All right, 302 of the Indian Penal Code and section 25 and 27 of the Arms Act. The case was committed next. The case was committed to the Court of Session after complying the due formalities, where the London trial court framed charges against the appellant as aforesaid, to which the appellant pleaded not guilty and claimed to be tried, and accordingly the sessions trial procedure was resorted to prove the guilt of the appellant. In order to prove its case, the prosecution examined 12 witnesses. To mention the names and what they are. The prosecution also exhibited 15 documents, just mention the name. The prosecution proved 14 material objects, name them. The defense plea of the appellant is one of denial, and it was further pleaded that a false case has been foisted against him. The next para. The London trial court, after assessing the oral as well as documentary evidence on record, came to hold that the gun recovered from the spot, gun bracketed MO1, recovered from the spot was used in firing at the deceased, causing his death. The London trial court further held that the plea of the appellant that it is an accidental fire cannot be believed, more so when there is no independent evidence on his side. It was held that in view of the evidence of PWs 1, 2, 3, and 5, corroborated by the medical evidence, it appeared that when PW3 Sukru dissuaded the appellant from quarreling, the appellant became furious at the spot, left the place, brought out the gun after some time, and fired, aiming at PW3. But due to sudden intervention of the deceased, it was the deceased who received that injury instead of PW3 and succumbed to the same at the spot. The London trial court held that the prosecution has succeeded in establishing the charge under Section 302 of the Indian Penal Code. The Lennon Trial Court further held that since previous sanction of the district magistrate as per Section 39 of the Arms Act has not been obtained, the charge under Section 25 of the Arms Act in contravention of the provision under Section 3 of the Arms Act would fail, and accordingly acquitted the appellant of such charge. However, it was held that in view of the chemical examination report of the State Forensic Science Laboratory, which has been marked as Exhibit 15, it was held that the prosecution has succeeded in establishing that the appellant used the firearm without any license, for which he is liable under Section 27 of the Arms Act. Accordingly, the appellant was found guilty under Section 302 IPC and Section 27 of the Arms Act. Mr. B.K. Rogert, Land Counsel, appearing for the appellant, contended that during course of sudden quarrel being provoked, the appellant seems to have fired gunshot at PW3, and he was having no intention to kill the deceased. And since the deceased came on the way, accidentally he was hit with he received the gunshot injuries. The Land Council further submits that the evidence has come on record that the appellant didn't know how to use the gun. And therefore, it cannot be said that aiming at the right side chest of the deceased, he fired gunshot. The Land Council further argued that in the first information report, it is mentioned that while firing gunshot, the appellant was at a distance of 30 feet away from the deceased, and the doctor who conducted post-mortem examination, Dr. Bracket Kordian, PW8, states that the gunshot was made at a distance of ranging 1 to 2 meters, and therefore the ocular testimony runs contrary to the medical evidence. And therefore, it's a fit case where either benefit of doubt should be extended in favor of the appellant, or he may be this conviction under section 302 IPC be altered to one under section 304 part 2 of the Indian Penal Code. He relied upon the decision of the Honorable Supreme Court in case of Tiandu.
Order.
31.
Kasiram versus State of MP, reported in AR 2001 Supreme Court 2902. Mr. Rajesh Tripathi and an additional standing counsel, on the other hand, supported the impugned judgment and contended that the eyewitnesses have consistently stated that during quarrel, the appellant left the spot, and when he came back, he was armed with a gun. And then he fired at PW3. But since PW3 remained behind the deceased, the bullet, the gunshot injuries were caused to the deceased on the right chest. And in view of the principle of transfer of malice as per section 301 of the Indian Penal Code, the London Trial Court was justified in convicting the appellant under section 302 of the Indian Penal Code. The Land Counsel for the appellant relied upon the decision of the Honorable Supreme Court in case of Rajbir Singh versus State of UP, reported in 2006, 4 Supreme Court cases 51, and Jagpal Singh versus State of Punjab, 1991, supplementary bracket 1, Supreme Court cases 549. The Land Counsel further argued that the appellant was found at the spot in an injured condition, and the weapon of offense, that is the gun, was also seized from the spot. And the evidence of the prosecution witnesses have not been shaken at all in the cross-examination. And the doctor who conducted the post-mortem examination stated that the cause of death was due to shock and hemorrhage as a result of injuries to vital organ like lung, and the injuries are possible by gunshot. And therefore, the medical evidence corroborates the ocular version of PW's 1, 2, 3, 5. And therefore, there is no merit in this appeal, same should be dismissed. Adverting to the contention raised by the Land Counsel for the respective parties, let us first discuss about the nature of death of the deceased. The postmortem report has been marked as Exhibit 5, And the doctor who conducted postmortem is none else than PW8, who has stated that on 18/4/99, he conducted postmortem examination and noticed the following injuries. Quote these injuries. On dissection, he noticed one so. He further stated that all the injuries were consistent with the firearm injury and are antemortem in nature. And he further stated that the cause of death was due to shock and hemorrhage as a result of the injury to the vital organ. And time since death is within 36 to 48 hours of the postmortem examination, and the injuries are sufficient to cause death. The Land Counsel for the appellant has not disputed that it's a case of homicidal death. After the London trial court has also arrived at such conclusion. After going through the inquest report, postmortem report, the evidence of the doctor, bracket ray, PW8, we are of the humble view that the prosecution has successfully proved that the deceased met with a homicidal death, and on account of gunshot injuries, he died. Now, coming to the evidence of the eyewitnesses, it appears that PWs 1, 2, 3, and 5 are the eyewitnesses to the occurrence. PW1, who is the son of the deceased, has stated that since his younger brother Ganapati Kisan had killed an ox, he was hosting a feast on the bank of river Sankha at the relevant time of occurrence, and about 30 to 35 persons of his caste were present in the feast, and they were all sitting to take the meal. And at that time, the appellant Mahadev Kishan raised commotion on the issue of service of meat curry to him. He further stated that PW3 Sukru Kishan, who was the elder brother of the father of the appellant, intervened and tried to dissuade the appellant from his indulgence of quarreling for nothing, for which there was hot exchange of words between the appellant and PW3, and the appellant left the spot and returned after some time with a gun, and he threatened PW3 to fire at him. But PW3 ran and took shelter behind the back of the deceased, and when the deceased tried to pacify the appellant without paying any heed, the appellant fired at PW3, but the bullet hit at the right side chest of the deceased, and he fell down on the ground and died instantaneously. PW1 further stated that the persons present at the place overpowered the appellant and kept him in captivity till the arrival of the police. In the cross-examination, PW1 has stated that he had never seen the appellant moving with or using gun prior to the occurrence, and he had no knowledge that the appellant was possessing a gun. He further stated that the appellant didn't know how to use the gun. He stated that the appellant was invited to the feast So suggestion was given to PW1 that when appellant quarreled unnecessarily with the deceased, unnecessarily, the deceased brought out a gun from the place of concealment and tried to terrify the appellant by showing the gun to him, and that the appellant tried to snatch away the gun from the deceased, leading to tussle between the deceased appellant and PW3, and in that process, the pellets went off to hit the deceased as well as the appellant. He has also denied the suggestion given by the learned defense counsel that death of the deceased was accidental in nature. The other witnesses, eyewitnesses, have almost stated in similar tone that about the quarrel, sudden quarrel between the appellant and PW3, and appellant leaving the spot, coming back after some time with a gun, and then there was intervention from the side of the deceased to dissuade the appellant, and then there was firing made by the appellant at PW3, but it hit at the right side chest of the deceased. Though the witnesses have been cross-examined at length, but nothing has been elicited to disbelieve the testimony of all these witnesses. It is correct that the doctor who conducted post-mortem examination has stated that the gunshot was made at a distance of ranging 1 to 2 meters. And in the first information report, it appears that the appellant was standing at a distance of about 30 feet from PW3 and was threatening him to kill, holding the pistol. And at that time, the deceased intervened and tried to dissuade the appellant when there was firing. But most peculiarly, none of the witnesses have been asked about the distance between the appellant and the deceased at the spot when the firing was made. The informant was not confronted with the first information report, stop. First information report cannot be used as substantive piece of evidence. If there are any omissions or contradictions in it which the defense want to prove, then the recital of the first information report is to be confronted to the concerned informant first. And the same having not been done, and nothing has been brought out record about the distance of between the appellant and the deceased at the time of firing gunshot, we cannot held that when the firing was made, the appellant was at a distance of 30 feet from the deceased, and therefore the nature of injury noticed by the doctor who conducted post-mortem examination was not possible due to such firing. The gun and aluminum caps and lead which were seized at the spot were sent for ballistic experts' opinion, and the report, which has been marked as Exhibit 15, indicates that the exhibit marked as A is a country-made SBML gun having all essential parts of a firearm such as trigger, trigger guard, nipple, hammer, barrel, stock, etc. On examination, it was found that the gun was in a working condition and capable of discharging projectiles, and therefore it is a firearm as defined in the Arms Act. The report further reveals that chemical examination of the barrel washing of the country-made SBML gun revealed presence of gunpowder (black powder residue), showing that the gun has been used for firing. Therefore, In our humble view, the prosecution has proved that it is on account of gunshot the deceased sustained injury on the chest and his death took place on account of such injuries. Now the question crops up for consideration whether the act committed by the appellant would come within the purview of section 302 of the Indian Penal Code or any lesser offense. The learned counsel for the appellant placed reliance in the case of Kansi Ram, wherein
Which paragraph?
31.
in paragraph number
31.
Acha, wherein it is held as follows. Quote paragraph number 31 in its entirety. That is 304 part 2. Okay. The Land Council for the state, you placed reliance on two decisions, no?
First is
That
Jaguar,
is Acha.
that is Parak.
In the okay. Jagpal Singh, which paragraph you are relying?
Parak 3, man.
In paragraph 3, it is held as follows, quoted from that paragraph. Stop. He further placed reliance in the case of Rajbir Singh. Which paragraph?
Parak 4, 5, and 6, man. 6 and 7.
No, those are the from other decisions that has been quoted. Any finding on this?
Yes, man. The 7. Parak
7.
7.
Okay.
Both the cases
And
the right to private defense?
Not private defense.
Okay. Both the cases placed reliance placed by the relates to right of private defense. In the case in hand, on analyzing the evidence on record, it appears that there was no previous dispute between the appellant and the deceased. It further appears that the occurrence took place all on a sudden and some kind of disturbance took place in the feast for which there was quarrel between the appellant and PW3. When there was hot exchange of words between the two, the appellant left the place, and after some time, he came to the place with a gun. It further appears from the evidence on record that the appellant didn't know how to use a gun. And after reaching at the spot, he threatened the PW3 to kill, and PW3 went and hid himself behind the back of the deceased. He wanted to terrify and he wanted to terrify the people around. And till that point of time, he had not stated anything to the deceased. But when the deceased tried to pacify him and intervened, all the witnesses have stated that the appellant fired gun aiming at the PW3, which hit, and the bullet hit at the right side chest of Natha Kishan, the deceased. In the case of Binit Kumar Chauhan versus State of Uttar Pradesh, it is held as follows. Quote from paragraph number 13, TO2. No, it is not 13. It is actually 16 and 17, right? In the same. The factual aspect of the said case is almost similar. And you also quote 304 part 2 the second part of so and so. Okay. So 17 inch. In view of the ratio laid down in the case of Vinit Kumar Chauhan, and taking into account the factual scenario, the evidence of the eyewitnesses, we are of the view that when a sudden quarrel ensued during the feast between the appellant and PW3, the appellant left the spot, and since he had no previous dispute with the deceased, and when he came back to the deceased to the spot holding a gun and tried to terrify others, including PW3, the deceased intervened, and the appellant fired single shot at the deceased, which hit at the chest of the deceased, is a single shot at PW3, which hit at the deceased on his right side chest. Since the act was done in a heat of passion without any premeditation, and when the evidence on record indicates that he was not an expert in using gun, we are of the view that the offense committed by the appellant would come within the definition of culpable homicide not amounting to murder. And therefore, we are inclined to bring down the offense from the first degree of murder to culpable homicide not amounting to murder, punishable under the second part of section 304 IPC. In the result, the appeal is partly allowed. The conviction of the appellant under section 302 of the Indian Penal Code is hereby set aside, and instead he is convicted under section 304 part 2 of the Indian Penal Code. So far as the offense under section 27 of the Arms Act is concerned, the evidence is consistent that the appellant has used the gun which was recovered at the spot, and therefore the sentence of imposed by the London Trial Court for such offense, conviction of the appellant under section 27 of the Arms Act and the sentence passed thereunder stands confirmed. It is stated that the appellant was at the initial stage was taken into judicial custody on
21st for 21 तारीख same day ना 21 तारीख 5 दिन बाद
उठाओ दिए सेकंड पेज को जाओ फाइनल फॉर्म रो उठाओ जस्ट a minute और ठीक है
it will 10 भी क्वेश्चन
नो नो देखिए दो श्योर है और ठीक ऊपर उठाओ नहीं बैक करছো তুমি তাকো और स्क्रॉल करो और स्क्रॉल करो और ठीक है हाँ just a minute was taken into was taken into judicial custody on 22/4/1999 when he was released on bail, and he was released on whether the order sheet dekhi trial court ro accused produced in so and so. Accused for the accused. Accused is produced. LCR का ये दो जो accused is produced, not produced in court. Okay, he was released on bail on by the order. The order was passed on 31/7/2000, and he filed the bail bonds on 5/8/2000. So like on, and he was directed to be released on bail as per order dated 31/7/2000, and after filing bail bonds, he was released from custody on 5/8/2000. Okay. No, 5/8/2000 neither. No. Documents of bailer accepted kala, but 26/8 रे पुणी देखुची से produced in custody रे थिला
22/4/2019 रे अरेस्ट हेले 31/7/2000 बेल आइछि
बेल इजे
31/7
अच्छा हाँ 8 असिला accused is present okay on bail हाँ ठीक है right then after conviction you are taken into custody
my lord
right because तापर सब देखुची present माने अपन उपस्थित थिले
तापर 6 जजमेंट पर 6
जजमेंट के भेला प्रोनाउंस होला
2005
25 to 2005
and after pronouncement of the judgment he was taken into judicial custody and released on bail by this court on
9/8/2011
9/8/2011
6 years 6 months ହେଇଥିଲା ଜଜମେଣ୍ଟ ବେଲ ଜଜମେଣ୍ଟ ପରେ
ଆଉ ସେ ଜଜମେଣ୍ଟ ପରେ ହେଇଥିଲା 6 years
6 months
ଆଉ ଏ ସେତେବେଳେ କେତେ ହେଲା
ସେଟା ହେଲା
ବେଲ କହିଲି ପରା ଆପଣଙ୍କୁ କଷ୍ଟଡି ଡେଟ୍ କେବେ ଗଲା କହିଲି କେବେ କହିଲି taken
22/4/2019 ରେ
22/4/2019 ରେ ଗଲା।
ଆଉ 31/7/2031 ରେ ବେଲ ଆମେ
31/7/2000
ବେଲ ଆଲାଉ ହେଲା।
ହଁ ତାହେଲେ 1 year ରହିଲା। So is in custody certi era 1 year. 1 year 3 months. So it is more than 7 years and 6 months, right?
ଆଜ୍ଞା
तो देखिए कि लिखिबो ताकू कस्टडी टा हला एटू हाई कोर्ट रो बेल ऑर्डर the conviction just stands confirmed since the appellant has remained in custody for such and such period कर देवे है ना during the pendency of the case and the trial as well as in the pendency of the appeal है ना the sentence is reduced to period already undergone. He has remained in custody for such and such period, therefore the sentence is है ना 304 part 2, so that is এটা को पेपर दिन तो बढ़िया देवा है ना all right.
Pardon me, my lord. Item number 83, my lord. A very urgent matter, my lord. The cardiac patient, my lord.
Well, you will call one by one.
Item 139, my lord. I have interim application I have filed, my lord, that I have not pressed, my lord.
My lord, kindly taken up today, my lord. Oh, sorry.
এটা কোন বাহার করে রয়েছে এটি এরকম ডিভিশন বেঞ্চ রে এটা বাহার করে রয়েছে এটি আছে পুরো matter ଅଛି ବୋଲି କେମିତି ଫାଇଲ ନାହିଁ ଅଛି ଏଇ 25 ତାରିଖ ଅଛି this matter ଏଟା କେତେ ନମ୍ବର ହେଲା
Pardon, my lordship. Item
pardon your lordship
item 235, my lordship.
report call for jail superintendent. Yes. Item 235, your lordship. This is the appeal in bail, my lord. Your lordship earlier directed to the state council to take instruction. The matter is already amicable settled between the parties. And the informant already filed a compromise affidavit. Which one? Item 235.
235, my lordship. I am appearing to the petitioner, my lordship. Priyavatam Rana.
It's a case of conviction.
Case of bail, my lord. Bail.
What is the offense?
Offense is, my lordship, 3762 N 506 34 YPC, my lordship. And 3 SC stick. Elengoti 3 SC
When the
stick.
matter reaches, we'll see that. Yes, next.
Yes.
All the matter.
Yesterday I have mentioned, my lordship. Yes.
Pardon me, my lord. Item 83, my lord. Kindly taken up today. The appellant is the cardiac patient, my.
Yes, call the matter.
Item number 2. Item 2, I pray for a passover. Mr. Panda is on his legs.
No, these two matters stay
my
of
senior is
conviction
here.
since today the trial is to be commenced, that election trial. We'll keep it on we commencing from 25th. So dita ka matter rakhi diyantu 25 tarikh gale Mr. Sanjay Kumar Das ko presence
Citations, my lord.
Who
In this matter. The
Item
lordship may kindly keep it in.
item number 2 re
3 re.
3 re
3 re.
Mr. Sanjay Kumar Das, standing counsel for the Vigilance Department, has filed some citations which are taken on record. So it is listed on to be on 25/9. Same etar kichi file korna di on consensus like the
Copy has been served on my learned senior friend.
कोटा कहले
ए 3 रो
citation न कोन कॉपी देबे अपन का लिस्ट टा देतियो
जो लिस्ट हम पैराग्राफ रे मेंशन करी जी सेटा मेमो ऑफ साइटेशन करी की फाइल करली दैट मेमो has been served on my learned senior friend.
Item 3, I am also filing my note.
Okay, Mr. Mishra, learned senior advocate, files the written note of submission, giving copy to the learned counsel for the additional standing counsel for the Vigilance Department.
25th, if this comes, in item number 3, the appellant is still in his service. Here, if the lordship would give me a couple of minutes, the complainant is dead. The other 2 witnesses have been declared hostile.
No, we'll take up this matter on 25th. The problem is that.
May I request for 26th?
हाँ किसी असुविधा नहीं
Let it come in the supplementary
अच्छा दीटा को ताले supplementary नहीं आसंदु 26 नरे so Mr. Panda this 26th
We are all great. The only pray in item 2, the name of Mr. Panda, we have filed the wakalat.
Yes, consent memo is there, my lord.
The name are not being reflected.
Deva Prasad Das name is reflected, but
तांको ना टा कोन कटी
कटा है
हमको consent
आपण फाइल कर दी चंद
आगे बहुत आगु.
All right, since Mr. Devasis Pandal and counsel has already entered appearance with the consent of the previously engaged counsel, the name of Mr. Devaprasad Das and S.R. Das shall not be reflected in the cause list henceforth, and in its place, the name of Mr. Devasis Panda be reflected. All right?
Grateful.
Oh, let's. May I please? The appellant convicted under section 304 part 1 of IPC for a period of 10 years, my lord, and section 149, 147 of 1 year each, my lord. And during trial, the appellant was on bail, my lord. And in similar circumstances, my lord, this honorable court granted bail some of the co-accused person in the split of trial case, my lord, relying upon the statement of the PW1, my lord, the wife of the deceased, my lord, PW1, who is the eyewitness to the occurrence.
What PW1 has stated?
Yes, ma'am. May I place the
PW1 is Nandai Ataka.
Yes, my lord. Informant, my lord. She is the wife of the deceased, my lord. And no weapon of offense has been used, my lord. Only kick and fist blow, my lord. In a number of cases, my lord, your lordship granted bail in split of trial case, my lord.
Kahin se order kahin?
Yes.
Adire PW1 of Doctor PW8.
PW6, my lord, in this case.
Yadir PW6.
PW6.
And present appeal.
Present appeal.
ये ऊपरटा देखिए नहीं ये राम ऑटो का ऑर्डरटा देखिए लिखिदेवे है किंतु खाली जो डॉक्टरटा सेतेबेले जेतु ट्रायल पेश करथिले सेमाने सेटारे पीएम डॉक्टरटा एग्जामिन हेतला PW8 वर्तमान ये जो ट्रायल PW6 हिसाब रे डॉक्टर एग्जामिन केतबेले सेति चेंज हो बाकी सब रहिबो हला स्टे रियलाइजेशन ऑफ फाइन कर दे bail allowed stay relation of fine. Yes.
May plus one. Running page.
Mr. S.K. Bhansdev. Next. Pass over Garam.
Item number 25.
Item 25 refer.
Okay, after the Sora vacation.
Item number 26.
Yes, Mr. Behra.
Mr. Pandey is appearing.
Yes.
This is a case where I have challenged the cognizance, my lord, which has been taken under the SC and SC Act, special law. Now, my lords, a complaint was filed before the special judge against this present petitioner and for commission of offence under section 3(1)(r) and S of the SC and ST PO Act with the prayer of examining the complainant and the witnesses and cognizance thereof was taken, my lords.
Okay, it seems that in the order dated 6/1/2023,
My lords.
I have noted down your contention. So you are challenging that taking of cognizance and issuance of process in the complaint case mainly on the ground that the complainant, though he was examined, his initial statement was recorded under section 200 CRPC, but when inquiry was held under section 202 CRPC, he was not examined. So that is one submission. So second submission is that though he has named 5 witnesses in the complaint petition, but examined only 2 of them,
Yes,
and the remaining witnesses were declined. So you said that that is also not permissible and illegal. So now the decisions which are being relied upon you, one is that Gokulananda Mahanti, the other is Sibji Singh.
my lords.
So these 2 decisions you relied upon, I have noted down it.
My lords.
Now,
My lords.
subsequent decision, including the decision of the Honorable Supreme Court, also says that if the statement has already been recorded, the complainant statement has been initial statement, that is called initial statement, that has been recorded, then it is discretionary on his part, the complainant, to examine, to put forth himself to be examined during inquiry under section 202. He may examine or may not examine himself, but he has to examine the other witnesses. So that is the position, and he cited also that decision to that effect.
Flag wilders.
And so far as second aspect is concerned, that statute itself says that complainant shall examine his witness. His witness doesn't mean that all the witnesses named in the complaint petition, but which he chooses to examine. Suppose he has named 5 witnesses, and after filing of the complaint petition, 3 of them are not in a position to support the case of the complainant. So the complainant may not like to examine them during 202 inquiry. So that is why whomsoever he wants to examine, he will examine. For the rest, he has to file a memo declining that I don't want to examine. If it is sessions trial, then that is mandatory in nature. And because all those witnesses are again to come during trial before the court of session, and this statement which has been recorded under section 202, since no 161 obviously would be there, this statement would be utilized as previous statement, and it may be necessary for proving the contradictions, etc. So that is why it is stated that in such case it is mandatory. But again, if he declines some of them, even in a sessions trial case, so he is precluded from examining them during course of trial. Only the witnesses whom he has examined during 202 inquiry in a sessions trial case only be permitted to examine them. So this is the position of law. So on this ground, how do you say that taking of cognizance in a complaint case and issuance of process against you is illegal?
Lords, I will first draw my lords to the complaint now, my lords.
Yes.
It is page 17. My lords, as far as the act goes, my lords, the complaint is the date and time and place of occurrence has been stated as 25/11/2016. I'm reading page 17.
Yes, I got it here.
At 2:30 p.m. in the block office of the education officer Chhatrapur, and on 31/3/2017 at 4:30 at the gate of the office of district education officer Barampur district Ganjam. And therefore in the complaint he has started the complaint case with paragraph 1. What's the next page? That the complainant is a scheduled caste person being so and so by caste. The complainant has been working as an assistant teacher in charge headmaster so and so Polsara block district Ganjam since so and so, and the complainant was the president of so and so so and so. He has given the detail of his own caste, millets. To attract the provision of SC/ST Act, millets, the complainant in the complaint nowhere speaks that the present appellant was aware of the caste of the complainant, millets. That is one limb of submission which I would like to draw first. Therefore, I want to place the entire complaint at large, millets.
No, what are the offenses under which cognizance has been
Well,
taken.
it's only under section 3(1)R as of the SC Act.
1S also.
No,
that
three
is at-
three one
31R and 31S.
31R and 31S.
That is
देखिए এটা SC/ST Act টা দেখি।
P1R and P1S.
R is intentionally insults or intimidates with intent to humiliate a member of scheduled caste or a scheduled tribe in any place within public view. This is R. And S abuses any member of scheduled caste or scheduled tribe by caste name in any place within the public view. So what is the place where the occurrence took place?
Both are public places.
Public place.
That's
That is the place is at?
that is there. Running page 3 of that.
Complaint Millard it has
Complaint petition ରେ ଲେଖା ହେଇନି place of occurrence କୁ?
date ସେଇଟା ମୁଁ ପଢିଥିଲି
page 2 ରେ para 3 ଆଜ୍ଞା।
ହଁ ପରା ଲେଖା ହେଇଛି education block education acha at the gate of office of the district education office.
That is the first option. The subsequent appearance is the second page. Page number 3 also. There are also the accused who was at the entrance gate of the office by seeing the complainant again scolded the complainant by saying some.
So it is within public view.
Yes. There is
But what he is now telling his submission that merely because he is a member, the complainant is a member of scheduled caste, the offense should not be attracted unless you show that he knew it and knowing it,
committed it.
he deliberately, intentionally insulted because you are a member of that particular caste.
The allegation reads as lordship. Allegations read as ତୁ କେଉଟ ପିଲା ଚାକିରି ଚାକିରି ଖାଇଦେବି ତୋତେ ଭିକ ମଗେଇବି ରହ ତୁ ଗୋଟେ ଅତ୍ୟନ୍ତ ଛୋଟ ଜାତିର ଲୋକ ତତେ ସଭାପତି କିଏ କଲା ତୁ ଗୋଟେ ଛାର କେଉଟ ପିଲା ହୋଇ ଲାଞ୍ଚ ଦେବାକୁ ସମସ୍ତ ଶିକ୍ଷକଙ୍କୁ ମନା କରୁଛୁ ଗୁଣ୍ଡା ଲଗେଇ ତ ଅବସ୍ଥା ସାଂଘାତିକ କରିଦେବି it shows that he was very aware
that he is a member of
so that this plea is not sustainable. So also the second allegation page 3 lordship towards last I am reading it is pertinent to mention that on 31 India 17 the complainant along with one retired teacher namely Shyamsundar Pradhan and Bullu Biswal had been to meet the accused to his office Giri Road Barampur at 4:30 p.m. The accused who was at the entrance gate of the office by seeing the complainant again scolded the complainant by saying so abuse will again.
ଏଇ ୱାର୍ଡସ୍ ଗୁଡାକ ଯୋଉ କହିଛନ୍ତି ଆପଣଙ୍କର 200 statement ରେ ଏଇ ୱାର୍ଡ ଅଛି କଣ ତା ପୂର୍ବ ଦିନ ରାତିରେ ଘୋଷି ଦେଇଥିଲେ କି ନା କଣ ଯୋଉଦିନ ଏଭିଡେନ୍ସ 200 statement ଯୋଉଦିନ ରେକର୍ଡ ହେଲା ତା ପୂର୍ବ ଦିନ ରାତିରେ ଘୋଷି ଦେଲେ ନା କଣ ଏଇଟା ଏତେ ଗୁଡାକ ଲାଇନ ନା 4-5 ଲାଇନ ସବୁ ଗୁଡାକ ପୁରା କନସିଷ୍ଟେଣ୍ଟ ଅଛି ଆଇଦର ଆପଣ ଲେଖିକିନି ରଖିବେ ସ୍ଟେନୋ ଡିକ୍ଟେସନ ନେଇଥିବେ ସେ କହିଲା ବେଳେ ଗାଳି ଦେଲା ବେଳେ ନଚେତ ତା ପୂର୍ବ ଦିନ ରାତିରେ ଘୋଷିଥିବେ ଏତେ 4-5 ଲାଇନ ଏତେ ସବୁ ଜିନିଷ ତୁ କେଉଟ ପିଲା ଚାକିରି ସୁଆଣ ସେଗୁଡା ସବୁ ପୁରା କନସିଷ୍ଟେଣ୍ଟ ଅଛି
କମ୍ପ୍ଲେନ୍ ପିଟିସନରେ ଯାହା ଲେଖିଛନ୍ତି ସେ କହିଥିବେ ଆଉ
Yes, Mr. Panda, what do you say? ଆଉ କିଏ ସାକ୍ଷୀ ଦେଇଛନ୍ତି ନା ସେଇ
Lakshmi kindly turn to track B, Lordship. There are
track B.
Yes, track B. Thus you see that the complaint petition is the first document. Thereafter, running page 5. That is the initial statement of the complainant. There also same thing is there. And page 8 is the copy of the report of 2. There also he has supported the case of the complainant.
ସେ ଯୋଉ ସାକ୍ଷୀ ଆପଣଙ୍କର ସେମାନେ ବି କହୁଛନ୍ତି କହିଲା ବୋଲି କେଉଟ ପିଲା ଆମେ ସବୁ କହିଲା
ଏସବୁ ଘଟଣା ଆମ ଆଗରେ ହେଇଥିଲା ସେ କହିଛନ୍ତି
Yes, Mr. Panda. ଏ ସାକ୍ଷୀ ଗୁଡାକ ଦେଇଛନ୍ତି ତାଙ୍କୁ ଭଲ ଶିଖାଶିଖି କରିକିନି ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଏଇ ଷ୍ଟେଜରେ ଆଉ ତ ଆସେସମେଣ୍ଟ କରିହବନି ତାକୁ।
Judge, I will
It is
only
he challenged the order of provenance lordship since 2017 and
Judge, I will
to 23 lordship.
Judge, that apart, my lords. Judge, what I would submit is, my lords, one thing your lordship may grant me one more opportunity, my senior will place it, my lords. Then
In fact, this case was posted for final disposal for twice at thrice lords. Repeatedly, this is the reason this case has been getting adjourned lords.
ହଉ ହେଲା ତାଙ୍କୁ ଆଉ ଗୋଟେ ସିନିୟର କୁ ଦିଆଯାଉ ଏଇ ଦିନ ମଙ୍ଗଳବାର ଦିନର ରଖିଦେଲେ ହବ।
Supplementary ଆଣିଛନ୍ତି କ୍ଲୋଜ କରିଦେବେ ତ
ସପ୍ଲିମେଣ୍ଟାରୀ ଆଉ 26 ତାରିଖ ରଖିବ ଆଉ no further adjournment.
that lords may defect.
Had Mr. Sudipto Ponda, Land Counsel for the petitioner and Land Counsel for the informant complainant for them. This is item number केते की चलती
26.
26. The after arguing for a considerable period, Mr. Panda submit that his senior, Mr. Devasis Panda, is supposed to address this court for some time. ଆସିବ ଆପଣ ଆଉ ଗୋଟେ ଦିନ ଦଉଛି ସେ କହିଲେ ତ 26 ତାରିଖ ରଖି ଦଉଛି list this matter on 26th of September 2020. Yes.
Not so good, sir. I don't call it so good, sir.
So now the election matter will be taken up. So 5 minute with डाकी दो मुझे.
there is an interim order in item 26.
Interim order.
Pardon to mention, my lord, 208 serial, my lord. I have filed a interim bail, my lord. The mother of the petitioner is serious ill, my lord. She has a
It has been listed.
My lord.
No, the IA has come.
My lord.
So instruction नहीं जानता था.
Item 208 है.
208 रो देखी दियो IA number for interim bail on the ground of ailment of the mother. Land Counsel for the state seeks some time to obtain instruction.
My lord, specific date में
25 तारीख रासियो.
My lord, my item is 50, my lord. Already honorable court stated that surety verification.
Exhibit 43.
Which page?
Exhibit EU.
Affidavit को पेज पर क्वेश्चन पचारिए.
कौन चाहिए टिकट खाली हम देखे दिए कौन एफिडेविट मतलब
नॉन एग्रीकल्चर लैंड तो जाइथिला
7B नॉन एग्रीकल्चर लैंड पेज 15 15
yeah yeah
exhibit Kimbo. ଆପଣ ଏଇ ହିବାନାମା ବଳରେ ଆପଣଙ୍କ ସ୍ପାଉସ୍ ମୌଜା ସୂତାହାଟ ଖାତା ନମ୍ବର 41 ପ୍ଲଟ ନମ୍ବର 231 ର ପ୍ରପର୍ଟି ଗିଫ୍ଟ ରେ ପାଇଲେ। ଆଜ୍ଞା
जाइछि परा एटा
ନା ଯାଇଛି ମୁଁ ତା ପର କ୍ୱେଶ୍ଚନ
ठीक है
ଆପଣ ଏଟା ଗିଫ୍ଟ ରେ ପାଇଲେ
ସିଏ ପାଇନାହାନ୍ତି ତାଙ୍କ
ମାନେ ସ୍ପାଉସ୍ ଆପଣ ଏଇ ଯୋଉ ଆପଣଙ୍କ ଆଫିଡେଭିଟ୍ ଫର୍ମ 26 ରେ କଲମ 2 ର ଲାଷ୍ଟ କଲମ ରେ ଲେଖିଲେ କଷ୍ଟ ଅଫ ଲ୍ୟାଣ୍ଡ ଇନ୍ କେସ୍ ଅଫ ପରଚେଜ ଲାଷ୍ଟ ସିରିଏଲ 2 ଏଇ ଯୋଉ 10,000 ଟଙ୍କାରେ କିଣିଲେ ବୋଲିକି ଲେଖିଲେ ଏଟା ମିଛ କଥା ଲେଖିଛନ୍ତି।
କୋଉଠି କହିଲେ
last line of that page 15 cost of the land left side my lords will get cost of the land in case of purchase then second column 38,000 10,000 ऊपर serial number 2 रो से तळे लिखिले 10,000 रे किनिचंती so my question is that your declaration that you purchased that property in 10,000 is a false declaration because this property his spouse got in the by a gift deed
ଏଇଟା କେମିତି ଜାଣିଲେ ଏଇଟା ସେଇ ପ୍ରପର୍ଟି ବୋଲି ଗିଫ୍ଟ
सर ऊपर प्रॉपर्टी रो सीरियल 2 लिखिचंदी टॉप रे सीरियल 2 रे डिस्ट्रिक्ट कटक मौजा जोटा से कहले भूल हे जाई छ ओडिया बाजार सेटा सीरियल 2
अच्छा अच्छा ओहो
से सही तार कॉस्ट ऑफ ये लिखिले
ता माने सेटा होची 23 डिसमिल प्रॉपर्टी टा
आज्ञा
राइट
23 डिसमिल
आउ
1983 हिबानामा रेजिस्टर्ड हिबानामा
सेउटा देखि दिचंती 10,000 टंका रे
आज्ञा
किना आइची
आज्ञा
सेटा जेतु गिफ्ट डीड थिला त सेटा पैसा देखिबा कथा न एरा कोन कोहंतु अपन कोन
माय लॉर्ड से जेतु एथे 9,500 और 500 लिखा है कि 10,000
हां
से सीता को मेंशन कर देचंती बट इज ए गिफ्ट and
so it was not actually purchased at all it is a fact that my spouse by way of hibanama got the property from his father from her father got the property
of Mauja Sutta
of Mauja Odia Bajar
Suttahat ache aja hibanama
अच्छा of Mauja Suttahat खाता नंबर ठीक है तो
खाता नंबर प्लॉट नंबर एरिया ठीक है
खाता नंबर 41 प्लॉट नंबर 231 एरिया एकड़ सुन 0.023 decimal on 19/7/1983 which I have mentioned in my affidavit in form 26
exhibit 43
bracket exhibit 43 in column number 7 dot
7B
B for Bombay
again
7B then Roman 2
non-agricultural land
under the heading of non-agricultural land but while mentioning the cost of the land bracket re in case of purchase at the time of purchase, comma, purchase lego time of purchase, comma, though I have mentioned the value of the land,
cost
acha, the cost of the land to be.
My lord, I have mentioned rightly the cost of the land. It was mentioned 10,000 rupees. But wrongfully I have declared as a.
That is in case of purchase. You have not purchased. That's they are hinting out that you have not purchased this land. It's a gift deed. So there is no question of purchasing the land with rupees 10,000, right? So I have mentioned the cost of the land to be rupees 10,000, comma, the said land was in fact not purchased by me, but as I have already stated, comma, it was gifted to my spouse by his father, by her father on 1983. 1983
under exhibit EU.
Brackets ra exhibit e kete number exhibit
EU
byte exhibit lego EU. Stop. Yes.
So it has the cost of the land to be rupees 10,000. So it have to in case of purchase.
अच्छा ए ब्रैकेट लिखी होंगी इन ऊपर लिखा है पूरा अच्छा उसे लिख.
I have mentioned the cost of the land to be rupees 10,000.
अच्छा सेट लिख cost of the land outside लिख देंगे. In case of purchase at the time of purchase. Hala, to be sworn. Yes.
EX. तो आपण ए जो लेखिले 10,000 टका किणिचंती एटा आपण फॉल्स डिक्लेरेशन करचंती.
10,000 टका कोड पाइला कि कहले ये फिगर टा कोड आनले
तादर वैल्यू ऑफ द प्रॉपर्टी अछि डॉक्यूमेंट
से जो हिबा नंबर
वैल्यूएशन ऑफ द प्रॉपर्टी
ओ सेइथु नहीं आछो
रजिस्ट्रेशन
ना ना ठीक अछि मु सेइथु आनी कि
आज्ञा.
लेखि से आपु
wrongfully जे लिखिचंती लिखि देति मु ओवरलुक कर जाइछि से फैक्ट मु मिछो काई कहि.
नहीं 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 से 10,000 टंकार वैल्यू अछि बेली तारो
डॉक्यूमेंट
सेटा डॉक्यूमेंट हिबा नाम रे रिफ्लेक्ट हेछि.
आज्ञा.
All right. The value of the property gifted to my spouse as per exhibit EU was shown to be rupees 10,000, and accordingly, comma, I have reflected the same in my affidavit in form 26. सेटी नहीं आसन कॉलम ना पूरा भी नहीं आसन से जो कॉलम फॉर्म सब नहीं आसन the column was पूरा नहीं आसन 7B2 under the heading of हैला. Stop. It's not a fact that I have made false declaration by showing rupees 10,000 to be the cost of land bracket रे जो in case of purchase so and so. हाँ सेट नहीं आसन तो now 10,000 टका दरकार अच्छी पूरा swing so and so हैला. It's not a fact that I have made false declaration by showing so and so in my evidence in my affidavit in form 26 हैला. हाँ
Next paragraph.
Para na sub para?
No, paragraph.
Para
Like
98.
alga property.
All right.
ଦେଖନ୍ତୁ ଏଇଟା ସେଲ୍ ଡିଡ୍ ଅଛି ईश्वर दास अग्रवाल, माला देवी अग्रवाल, विकास कुमार भरालावाला, सुरेश कुमार भरालावाला, through you as their power of attorney or holder, you have executed and registered the sale deed in favor of your spouse.
Mark is aguru.
ଆଜ୍ଞା ଦେଇଛି ଗୋଟେ କପି EX.
କେତେ?
EX.
Oh, EX.
My lords, kindly see page 11.
Affidavit. 26 affidavit.
ଦେଖେଇବି ଆଗେ ଏଇଟାକୁ ଦେଖନ୍ତୁ, ମୁଁ ସେଇଟା ଦେଖେଇବି।
ଦେଖିବି ତା
ନା ନା ତା ସାଙ୍ଗରେ କାଲି ମୁଁ ପଚାରିବି ଆପଣ
ଡକୁମେଣ୍ଟସ କି ନ
ଆଗେ ଏଇଟା ସେଲ୍ ଡିଡ୍ ଦେଖନ୍ତୁ ଠିକ ଅଛି କି ନାହିଁ କୁହନ୍ତୁ ଆଗେ, ମୁଁ ସେଇଟା ଦେଖେଇବି ଆପଣଙ୍କୁ। ମୁଁ ନ ଦେଖେଇ କିଛି ପଚାରିବିନି, ସବୁ ଦେଖେଇବି ଆପଣଙ୍କୁ।
ଏଇଟା ହଉଛି ଗୋଟେ ସେଲ୍ ଡିଡ୍ ଯୋଉଥିରୁ ଜଣା ପଡୁଛି ଏଇଟା ଏକ୍ଜିକ୍ୟୁଟ ହେଇଛି 2007 ରେ। ଆଉ ଏଇଟା ଈଶ୍ୱର ଦାସ ଅଗ୍ରୱାଲା ଆଉ ମାଲା ଦେବୀ ଅଗ୍ରୱାଲା ସେମାନେ ସେମାନେ ଇଏ କରିଛନ୍ତି
he has executed as their power of attorney holder.
ଆଚ୍ଛା ମାନେ ବିକାଶ ମୋହନୱାଲା ସୁଆଂଶୁ ରିପ୍ରେଜେଣ୍ଟେଡ ବାଇ ଦି ଆଟର୍ଣ୍ଣି ହୋଲ୍ଡର। ଓହୋ ମାନେ ଆଙ୍କର ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ହୋଲ୍ଡର ହିସାବରେ ସେମାନେ
ବିକ୍ରି କରିଛନ୍ତି ପ୍ରପର୍ଟି ଆଟ୍ ସିଡ୍ୟୁଲ A
in favor of
his spouse.
Okay, spouse. What is your question? ସେ ଦେଖିଲେ ସାମ୍ନାରେ ତ
ଏଇଟାରେ ଆପଣ ଆପଣଙ୍କ ସ୍ପାଉସ୍ କିଣିଛନ୍ତି which is delineated and assigned shop numbers 13, 14, 15 at ground floor and 13, 14, 15, 16 at first floor and shop numbers 13A, 14A, 15A at basement floor. କିନ୍ତୁ ଆପଣ ଏ ଯୋଉ 13A, 14A, 15A, my lords can see affidavit at page 16.
16, ହଁ।
ଦେଖନ୍ତୁ
ସପ୍ ନମ୍ବର ଦେଖେଇଛନ୍ତି, ଗ୍ରାଉଣ୍ଡ ଫ୍ଲୋର ଦେଖେଇଛନ୍ତି।
ଗ୍ରାଉଣ୍ଡ ଆଜ୍ଞା ଠିକ ଅଛି।
ହଁ ଆଉ କୋଉଟା ଦେଖିନାହାନ୍ତି?
ଦେନ୍ ଫାର୍ଷ୍ଟ ଫ୍ଲୋର ବେସମେଣ୍ଟ ଫ୍ଲୋର ଟାକୁ ସବୁ ଯାକ ଫାର୍ଷ୍ଟ ଫ୍ଲୋର ମେନସନ ହେଇଛି। 13, 14, 15, 16 and 13A, 14A and 15A.
ଆଚ୍ଛା ଆଚ୍ଛା। ବେସମେଣ୍ଟ ଟାକୁ ସେଟା ବେସମେଣ୍ଟ ଦେଖିବା କଥା,
ସେଟା ଫାର୍ଷ୍ଟ
ଫ୍ଲୋର ରେ ଦେଖେଇ ଦେଇଛନ୍ତି। ଏଇ ଯୋଉ ତିନିଟା ବେସମେଣ୍ଟ ଫ୍ଲୋର ରେ ତିନିଟା ଦୋକାନ ଘର ରହିଛି ଯାହାର ନମ୍ବର ଦିଆହେଇଛି 13A, 14A, 15A। ଏଗୁଡାକ ହଉଛି ସବୁ ବେସମେଣ୍ଟ ଫ୍ଲୋର ରେ, ଆପଣ ତାକୁ ଫାର୍ଷ୍ଟ ଫ୍ଲୋର ଭିତରେ ଦେଖେଇ ଦେଇଛନ୍ତି। କଣ କହୁଛନ୍ତି କୁହନ୍ତୁ? ସବୁ ଠିକ ଅଛି, ଏଟା କଣ ଆପଣ କଣ ଯାହା କହିବେ କ୍ଲରିକାଲ ମିଷ୍ଟେକ୍ କଲେ। ଇଟ୍ ଇଜ ଏ ଫ୍ୟାକ୍ଟ ଦ୍ୟାଟ୍
mention all the details now.
ନାଇଁ ନାଇଁ ସେଇଟା କିଏ ମନା କରୁଛନ୍ତି, ସେ ଖାଲି ଗୋଟେ ଓମିସନ ହେଇଯାଇଛି ବେସମେଣ୍ଟ ଫ୍ଲୋର ଆଉ କଣ। ଇଟ୍ସ ଏ ଫ୍ୟାକ୍ଟ ଦ୍ୟାଟ୍ while mentioning the shop numbers under the heading of commercial building in column number 7, ସେଟା କେତେ ଆସୁଛି? column number 7,
7B,
B for Bombay,
ଆଜ୍ଞା
7B
Roman 3,
Roman 3, हाँ ठीक है, comma it's a fact that while mentioning the shop numbers under this one, so I have shown shop numbers 13A, 14A and 15A ନାଇଁ କମାଟା କାଇଁ ଦେଲେ ସେଠି 14A ପରେ ହଁ and 15A to be in the first floor, though exhibit EX indicates that those three subrooms, that is 13A, 14A and 15A are located in the basement floor. Stop. It is it's a clerical mistake to omit basement floor in that particular column. It's not a fact. कोई भी false declaration.
Okay.
It's not a fact that I have made false declaration. By mentioning the existence of the three soft rooms, existence of the Vernon बोला last spelling. Existence of three soft rooms. The aforesaid what a word is. The aforesaid three soft rooms in the first floor. Yeah.
ସେଇଠି ଆଜ୍ଞା ଯୋଉ ସେକେଣ୍ଡ ଲାଇନରେ ରହିଲା କଲମ 7(2)B Roman 3 of my affidavit in form
अच्छा
36.
हाँ of my affidavit तेरा नहीं सुन सके 43 हाँ सही है हाँ हाँ सही है it's a fact that while mentioning the shop numbers under the heading of commercial building in column number so of my affidavit so I have shown so to be in the first floor, though exhibit EX indicates those three shop rooms, that is so are located in the basement floor. It's a clerical mistake to omit basement floor in that particular column. It's not a fact that I have made false declaration by mentioning the existence of the aforesaid three shop rooms in the first floor. Yes.
I have not mentioned the first floor. ତା ଆଗରୁ ସେ ଯୋଉ
ଆପଣ
ପରେ ବେସମେଣ୍ଟ ଲେଖା ହେଇଥିଲେ ପୁଣି 14 13 and 15 ହେଇଥାନ୍ତା
ନାଇଁ ଆପଣ ଏଇ ନମ୍ବର ତିନିଟା ଦେଇଛନ୍ତି ସେଟା ବେସମେଣ୍ଟ ଫ୍ଲୋର ଲେଖିକିନି ତାପରେ ତିନିଟା ନମ୍ବର ଦେଖିବା କଥା ସେ ଯୋଉ ବେସମେଣ୍ଟ ଫ୍ଲୋର ଟା ଛାଡି ଦେଇ ଯାଇଛନ୍ତି ଆପଣ ଯେମିତି ଫାର୍ଷ୍ଟ ଫ୍ଲୋର ଦେଖେଇକିନି ତାପରେ ଲେଖିଲେ ନା 13 14 15 16 ସେମିତି ଲେଖିବା କଥା ଯେ ବେସମେଣ୍ଟ ଫ୍ଲୋର ତାପରେ ଏଇ ଯୋଉ ତିନିଟା ଆପଣ ଖାଲି ବେସମେଣ୍ଟ ଫ୍ଲୋର ୱାର୍ଡସ୍ ଦିଟା ଛାଡି ଦେଇଛନ୍ତି ହେଲା ସେଇଟା ହଉଛି ତାଙ୍କର କଥା ହଁ ବେସମେଣ୍ଟ ଫ୍ଲୋର ଟା ହଁ ଇଏ it's a clerical mistake to omit basement floor in that particular column. Okay, ठीक है. Yes.
ତାର
अच्छा ଏଠି ଗୋଟେ line କରୁନି. It's a clerical mistake to omit basement floor in that particular column before like before 13A, 14A and 15A. Before 13A and 14. Okay. हाँ ହେଲା ठीक है.
ସେଇ ସେଲ୍ ଡିଡ୍ ର Schedule B ଦେଖନ୍ତୁ
କୋଉଟା ଏଇଗୁଡା
ଆଜ୍ଞା ତାର ନେକ୍ସଟ ପେଜ 12
Schedule B ହଁ
ଆଜ୍ଞା
yeah
Schedule B ରେ ଆପଣ ଦେଲେ ସାବିକ ଖାତା 536 ସାବିକ ପ୍ଲଟ 739 ହେଭିଂ ପ୍ଲଟ ଟୋଟାଲ ଏରିଆ acres on 852 decimal corresponding to hall new khata number 159 and plot number 1278 by 14601280 by 1460 area acres on 32 decimals and HAL khata number 126, HAL plot number 1278 and 1280 having an area of 210 decimals. Total area acres for a portion of the aforesaid land. A portion of the aforesaid land further corresponds to HAL khata number 180 by 3, HAL plot number 1461 by 1604, 1460 by 1605, khata number 180 by 4. ଆପଣ ଏଇ କରସ୍ପଣ୍ଡିଂ ଖାତା ଆଉ ପ୍ଲଟ ନମ୍ବର ଆପଣଙ୍କ ଆଫିଡେଭିଟ ରେ ମେନସନ କରିନାହାନ୍ତି।
हाल खाता नंबर और प्लॉट नंबर
हाँ जोटा लास्ट इन लाइन फर्दर करस्पॉन्ड्स टू हाल खाता नंबर 180 by 3, हाल प्लॉट नंबर 1461 by 1604, 1460 by 1605, खाता नंबर 180 by 4
एतिकी मेंशन
हाँ प्लॉट नंबर ता परटा लिखिचंती किंतु एतिकी खाता और प्लॉट लिखिना
कोडी लिखचंदी आगे देखिले
सही सर पेज 16 रो फर्स्ट कमर्शियल बिल्डिंग रो मेट्रो प्लाजा सेकंड कॉलम रे
मेट्रो प्लाजा
से जोठी हमें शॉप रूम देखुथलो तारी ये रे जो खाता नंबर प्लॉट नंबर ता ऊपर है।
अच्छा खाता नंबर अछि तो
155 लिखिचंती
हां
से प्लॉट नंबर गुरा लेगा हाल खाता नंबर 126 से प्लॉट नंबर गुरा देइचंती से जो तले तीनटा रहिला ए पोर्शन ऑफ द एफोर्सेड लैंड फर्दर करस्पॉन्ड्स टू हाल खाता नंबर सो एंड सो प्लॉट नंबर सो एंड सो खाता नंबर सो एंड सो ता पर प्लॉट नंबर लिखिचंती बट ए दीटा खाता और दीटा प्लॉट लिखिना
हालटा नंबर लिखिना साबिक केटा लिख दीजंदी हो
नहीं हालटा लिखिचंती साबिकटा बिल्कुल लिखिनांती से हालटा से फेर म्यूटेशन हेची से फेर आउ थरे म्यूटेशन हेची जो फर्दर करस्पॉन्ड से फेर म्यूटेशन हेची
माय लॉर्ड
हां
जो तळे जोटा लिखा ହେଇଛି ସେଟା पर आम रेकॉर्ड ପାଇଁ रखा ହେଇଛି बट तार न्यू म्यूटेशन की हाल न्यू नंबर देखिथिबे ब्रैकेट लिखा ହେଇଛି न्यू खाता नंबर 155 प्लॉट नंबर 1278 by 140 and 128 इटा वी हैव मेंशन देयर इन द डिटेल्स यार तार कॉरेस्पोंडेंस ता संगे लीक डॉक्यूमेंट्स तार आवश्यकता नथला कि बोली हम देई
अच्छा I have not mentioned I have not mentioned हाल खाता नंबर 180 by 3 हाल प्लॉट नंबर 1461 by 1604 ठीक है छाड़ी की नहीं 1460 अच्छा ठीक है 1460/1605 and खाता नंबर 180/4 in my affidavit in form 26 in column number in my affidavit in column number ये जो 7 से ऊपर नहीं आसन ये जो रोमान 3 under the heading of commercial building हाँ सीट नहीं आसन under the heading of commercial building and so ready copy करी paste करूँ आज I didn't feel it necessary to mention the same in view of the details already furnished in respect of the land in that particular column.
Corresponding to HAL new खाता number.
ने हाल न्यू खाता नंबर तो कोड लिखी ना
अच्छी सर से शेड्यूल बी रे ऊपर अच्छी
शेड्यूल बी रे
सेल डी
हाँ नहीं नहीं एथी आपन को एथी रिफ्लेक्ट करिया था आपन को जो 43
एटी खाता नंबर पर ही हम मेंशन कर
खाता नंबर मेंशन करी सेटा अच्छी तो ऑलराइट नेक्स्ट
ଶୁଣନ୍ତୁ ଆପଣ ଏଇଟା ଆପଣ ମିଛ ଲେଖିଛନ୍ତି ବୋଲି ଆପଣ ଏ ପ୍ରପର୍ଟିର ପଟ୍ଟା ଦାଖଲ କରିନାହାନ୍ତି କେବଳ ସେଲ୍ ଡିଡ୍ଟା ଦାଖଲ କରିଛନ୍ତି
ଏଇଟା କଣ ତାଙ୍କ ତରଫରୁ ପ୍ରମାଣ
ଆଜ୍ଞା
EX ପରା
EX ସେ ଫାଇଲ କରିଛନ୍ତି
ଓ ଆଚ୍ଛା ହଁ what is your reply
my lord यार ये तो किसी अपार्टमेंट प्रोजेक्ट इतने म्यूटेशन नहीं नहीं इंडिविजुअल पट्टा रो ओनली सेल डीड फर्निश कराई
the property under exhibit EX is an apartment and individually individual cell deed is not available.
Individual cell deed is available.
Okay.
Mutation करी पट्टा individually.
अच्छा करी नाहंती
पट्टा कथा कहले
हाँ पट्टा कथा
पट्टा इंडिविजुअल नहीं परिबनी
मु इंडिविजुअल पर एई खाता प्लॉट आपण जोटा कहिल लिखिचंती 126 155 आपण जो खाता 126 155 मेंशन कर सेई खाता प्लॉट रो पट्टा आपण दाखिल करनांती जेहेतु आपण एफिडेविट रो मिछ कथा लिखिचंती
दिस खाता प्लॉट बिलोंग्स टू मेट्रो बिल्डर्स ओडिशा प्राइवेट लिमिटेड एंड आई वाज द मैनेजिंग डायरेक्टर ऑफ मेट्रो बिल्डर्स ओडिशा प्राइवेट लिमिटेड with that power only more registered in my spouse name so this khata belongs to company the sell the original patta and seti say all the flat owners are the owners of that patta so sila society को hand over कर दिया जाए after completion of the project so amar seti किसी rights न था तो मो पाखरी जहाँ individual sell लिखला मो spouse मो ताको submit कर दिया with the possession letter
तो नहीं ये जो प्रत्येक इंडिविजुअल प्लॉट रो प्लॉट पाई जो आरओआर
आरओआर था केमति आपन आरओआर ता रे जो 80 नंबर्स ऑफ फ्लैट 40 नंबर्स ऑफ शॉप्स अछि सो आरओआर ता तो म्यूटेशन होई पे
ऑब्वियसली सो
तो इट वाज माने सेटा सोसाइटी को हैंड ओवर कर दिया जाय
नो जे आपन रीजन टा में लिखुछ तो सो द प्रॉपर्टी सो एंड सो इज एन अपार्टमेंट एंड इंडिविजुअल आरओआर
मु आगे इंडिविजुअल आरओआर मागु नै था मु कहूची जो खाता नंबर आपण मेंशन करचंती आपण का एफिडेविट रे आपण से पट्टाटा दाखल से काहा नारे अछि से आपण अपार्टमेंट कर ठीक है जा ना ताऊ आपण से पट्टा दाखल करनांती जेहेतु आपण आधर मिछ कथा लिखिचंती
ऑलराइट इफ द प्रॉपर्टी सेटा काटी जंदो से यो खाली अपार्टमेंट करी पर्यंत रखन तापर काट हां स्टॉप इट्स नॉट ए फैक्ट that deliberately I have not filed the ROR
in khata number 126 and 155
khata number
155 and 126
155
खाता का सेल डीड
खाता हाल लेकुन तले हाल न्यू खाता नंबर लिखुन हाल ब्रैकेट रे न्यू हला खाता नंबर 155
and 126
and हाल खाता नंबर 130 126. It's notified that deliberately have not filed the ROR of so and so before this court. As I have mentioned falsely about such property, कोथरे false mention करजंदी बोली कोजंदी
ए जो affidavit form 26
falsely in affidavit in my affidavit sworn so
ମୁଁ ବୁଝିଛି
ଆପଣ ଦୁଇଟା ଏଣ୍ଟିଟି ଏକାଠି କରନ୍ତୁ
କୋଉ ଦିଟା ମୁଁ ଏଣ୍ଟିଟି କଥା ତ ପଚାରିନି ଆପଣ କହିବନ୍ତୁ let it be go also
it's notified that deliberately I have not filed the ROR of HAL so and so before this court as I have mentioned falsely about such property in my affidavit so and so. Yes. ଆପଣ ଯାହା କହିବେ କୁହନ୍ତୁ ମୁଁ ଲେଖିଦେବି କିଛି ଅସୁବିଧା ନାହିଁ ଆପଣ ତାର କ୍ୱେଶ୍ଚିନ୍ ଆପଣଙ୍କୁ ପଚରା ହଉଛି ଆପଣ
ମତେ ଆମେ ଆମକୁ ଯାହା ଦେଇଥିଲା ବିଲ୍ଡର ଡକ୍ୟୁମେଣ୍ଟସ ଆମେ ତାକୁ ସବମିଟ କରିଛୁ
କୋଉଥିରେ ସବମିଟ କରୁଛନ୍ତି
ଏ ଯୋଉ
ସେଲ୍ ଡିଡ୍ ରେ ଯୋଉ ଯାହା ଦେଇଥିଲା ଆପଣ ଦେଇଛନ୍ତି ତା ଏ ସେଲ୍ ଡିଡ୍ ରେ ଯାହା ପ୍ରପର୍ଟି ଡେସ୍କ୍ରିପସନ ଥିଲା ଆପଣ ସେ ପ୍ରପର୍ଟି ଡେସ୍କ୍ରିପସନ ଆପଣଙ୍କ affidavit ରେ ଦେଇନାହାନ୍ତି
it's not a fact that the complete description of the property
mentioned in schedule B
of exhibit EX have not been reflected correctly in my affidavit in form 26 in column number से जो नया सुन साते से जो कौन
7B Roman 3
under the heading of commercial building
7B Roman 3 metro plaza विषय तो था हुआ है नॉलेज
हाँ कोई नहीं under the heading of ये
metro plaza with respect to metro plaza
metro plaza metro plaza Roman 1 नहीं सेंटिया 1 में ये जो आई बड़े लग गए हाँ ठीक है It's not a fact that complete description of the property mentioned in Schedule B of से कौन कहिबे से आपण तो डिनाय कर दिला से आर्गुमेंट स्टेज रे सेटा को हबो अभिज्ञान हां
EM 11
ଏଟାର ସରିଗଲା କାମ ଏଟା नहीं ऊपर क्वेश्चन करिवे EH
EM ରୁ EM 11 ଗୋଟେ ସାଙ୍ଗରେ ହେଇଛି ସେଲ୍ ଡିଡ୍ 11
EM କଣ କହୁଛନ୍ତି ଏଟା EM ହଁ
EM 2 ଟା ଆଜ୍ଞା ଦେଖନ୍ତୁ EM 2
EM 2 ହଁ କୁହନ୍ତୁ এটা হচ্ছে সেম সেই स्पाउस को ना ହେଇଛି ଏଟା କି description of property କୋଉଠି ରାଶି ଓକେ B
page 14 ଅଛି
ହଁ 14 schedule A B ରେ ଆସୁଛି ହଁ କୁହନ୍ତୁ ପଚାରନ୍ତୁ
ଏଇଟା ଦେଖନ୍ତୁ ଏଇ ଏକ୍ଜିବିଟ୍ EM ରେ
EM/2 ନା
EM/2 ଆପଣ ଏବଂ ଆପଣଙ୍କ ସ୍ପାଉସ୍ ଫ୍ଲାଟ୍ ନମ୍ବର G05/E କିଣିଛନ୍ତି
ସିଟି ସେଲ୍ଟର ର ସେ schedule B ରେ ହିଁ ଲେଖା ହେଇଛି ସିଟି ସେଲ୍ଟର ବୋଲି
ଦେଖିଲେ କିନ୍ତୁ ଆପଣ ଆପଣଙ୍କ ଆଫିଡେଭିଟ୍ ଫର୍ମ 26 ରେ ଫଲ୍ସ ଡିକ୍ଲାରେସନ କରିଛନ୍ତି ଆପଣ ଫ୍ଲାଟ୍ ନମ୍ବର F/5 କିଣିଛନ୍ତି ବୋଲି
କୋଉଠି ସେଟା ଦେଇଛନ୍ତି
ଯୋଉ କଲମ ପେଜ 17 सिटी सेल्टर यूनिट नंबर पर प्लॉट ग्राउंड फ्लोर फ्लैट नंबर 1A 2B F5
सिटी सेल्टर हाँ ये प्रॉपर्टी टा
ये जो F5
F5 टा कोड देखिए सिटी सेल्टर हाँ सिटी सेल्टर कोटा कहउछंदी आईबी पर देखाई जे एठी गोटे आईबी तो अछि आदिरे एपटे माने रेसिडेंशियल बिल्डिंग हाँ हेडिंग रे अछि तो
आगे आगे
हाँ सिटी सेल्टर रो दिस इज सिटी सेल्टर
आगे
सिटी सेल्टर रो येटा होछि कॉलम नंबर फर्स्ट कॉलम
रे F/5 1A 2B F/5
हाँ बट एटा से जो 5/E टा ता तळे लेखा हिची गोटे 5/E बोली
सेटा या फर्स्ट फ्लोर सेटा फर्स्ट फ्लोर
ओ फर्स्ट एटा ग्राउंड फ्लोर
एटा ग्राउंड फ्लोर
अच्छा ओ ग्राउंड फ्लोर होची एटा ग्राउंड फ्लोर फर्स्ट फ्लोर सेकंड थर्ड फ्लोर द ग्राउंड फ्लोर प्रॉपर्टी टा देखै जंती फ्लैट नंबर 1A
आगे 2B
सेटा कोड पाइल
सेटा ठीक अछि तांकर अलगा सेल
अच्छा
ठीक अछि
ओके खाली जो F5 टा
भूल अछि
एटा हवा कथा 05/E हवा कथा या कोजन तो
आगे
एटा 5/E जगह रे लिखि जंती F/5
एवं आपनका स्पाउस को कॉलम रे पेज 18 पेज 18 टॉप फ्लैट नंबर ग्राउंड फ्लोर 1A 2B 05 लिखिछंत
1A 2B तो अच्छी ठीक
1A 2B ठीक अच्छे
हाँ but 05 सेटा हवा का था 05 by E हवा का था
आगे
थोड़े E omit कर दिए अच्छा yes Mr. This ceremony. Yes Mr.
खोजुଛି ଟିକେ କୋଉଠି କଣ ଛାଡି ଦେଇଛନ୍ତି
ସେ omission ହେଇଛି ଆଉ ଏଟା କି omission ଆପଣ ତାକୁ ନା ଯାହା ଦେବେ ଲେଖା ହବ କ୍ଲରିକାଲ ମିଷ୍ଟେକ୍ କି କଣ ଆପଣ ଯାହା ଦେବେ କହିବେ ଲେଖା ହବ ଛଡା ତ ହେଇଛି ଭୁଲ ତ ରିଫ୍ଲେକ୍ଟ ହେଇଛି
ଟାଇପ କଲା ବେଳକୁ
ଠିକ ଅଛି ଟାଇପର ଏତିକି ହବ ଲେଖନ୍ତୁ it's a fact that ଆଉ ଗୋଟେ paragraph କରିଦିଅନ୍ତୁ it's a fact that the property described in the cell deed by the exhibit EM by 2 EM by 2 has been reflected under Schedule B of the said cell deed to be flat number 05 oblique capital E situated in the ground floor of the multi-storied building but while of the complex level multi-storied building of the complex having name and style
city shelter
of city CITY shelter inverted comma but while mentioning the property in column number
7B Roman 4
7B नहीं सुना पूरा 7B bracket Roman 4 under the heading of residential building bracket लिखी दूंगा including apartment under the heading of residential building bracket रे कौन दूंगा including apartment buildings कर दियंतु residential building including apartment comma I have mentioned the flat number 2B flat number पूरा लिखो NUMB है number 2B F by 5
And
inadvertently.
and in my spouse column, flat number 05.
So far as my column is concerned, and in the column of my spouse, comma, the flat number has been mentioned to be 05, and such mistakes are typographical, are typographical. Stop. It's not a fact. Say suggestion that deliberately
I have made a false declaration.
Deliberately have made false declaration by mentioning the wrong flat number, of city shelter. City shelter to inverted comma in my affidavit in form 26. Okay.
ଦେଖନ୍ତୁ ଏ ସେଲ୍ ଡିଡ୍ରେ ଆପଣ ଆଉ ମିଷ୍ଟର ପିୟୁଷ ଧାରୀ ମହାନ୍ତି ମୌଜା ରୁଦ୍ରପୁର
କୋଉଟା
ସେ ଯୋଉ ଦେଇଛି ଡକୁମେଣ୍ଟ ଇଜେଡ୍
ନାଇଁ EM by 2 ତ
ନାଇଁ
ଗଲା
ଇଜେଡ୍
EZ ଦିଅନ୍ତୁ ଏଇଟା ପ୍ରଶ୍ନ ପଚାରନ୍ତୁ।
ଏଇ ପ୍ରପର୍ଟିରେ ଆପଣ ଆଉ ମିଷ୍ଟର ପିୟୁଷ ଧାରୀ ମହାନ୍ତି ମିଶିକି ମୌଜା ରୁଦ୍ରପୁର ଖାତା ନମ୍ବର 345 ପ୍ଲଟ ନମ୍ବର 414 ଛକ ନମ୍ବର 219 ଏରିଆ 3 ଏକର 13 ଡିସମିଲ ଜମି ଆପଣ କିଣିଛନ୍ତି।
କଣ ଭୁଲ ଦେଖିଛନ୍ତି
He has
କିଣିଛନ୍ତି
not mentioned about it
କୋଉଠି
in affidavit.
ଟୋଟାଲ ଲେଖିନା
ନାଇଁ
ପ୍ରପର୍ଟି ଡେସ୍କ୍ରିପସନ ଟା କେତେ ପେଜ ରେ ଅଛି?
ସେଇ ଚାଲିଲା ଆଜ୍ଞା ସେଇ ପର୍ଟିକୁଲାର ଆପଣ ପେଜ 18 ଦେଖନ୍ତୁ।
ଏଇ ଯୋଉ
Page 18 top. Mauja Rudrapur, Khata number 345, plot number 414. Though this property has been purchased, total area is 3 acres.
ମୌଜା ରୁଦ୍ରପୁର କୋଉଠୁ ପାଇଲେ?
Top ରେ ଅଛି page 18 ରେ
18 ଏଇ କୋଉଟା ଦେଲେ?
evidence ନାଇଁ ଡକୁମେଣ୍ଟ ଟା ଦେଖୁଛନ୍ତି?
ହଁ
ଡକୁମେଣ୍ଟ affidavit ରେ page 18
ହଁ ଏଇଠି କୋଉଟା
top ରେ district Khurda
ହଁ
Mauja Rudrapur.
ହଁ
Khata number 345, plot number 414, then flat number so and so, first floor. But this sale deed, my lords will get it at page 84 ऊपर इनके लिखा है। Before इनके ऊपर।
खाता नंबर 345 ठीक ଅଛି, प्लॉट नंबर 414 ठीक ଅଛି, फ्लैट नंबर फ्लैट नहीं अच्छा चलो हाँ तो इरा कौन है जी कौन भूल अछि?
This land has not been disclosed. Area 3 acre 30 decimals. He along with one Piyush Dhari Mahanti has purchased.
हाँ
This has not been disclosed in his affidavit in form 26
ଏଇଟା ଯୋଉଟା ହେଇଛି
ସେ ଖାଲି flat ଗୋଟେ କୋଉଠୁ ଲେଖିଛନ୍ତି
ହୁଁ
but area is 3 acre 13 decimal
ଏରିଆଟାକୁ ଓମିଟ କରାହେଇଛି
area हाँ area ये खाली area ଲେଖିଛନ୍ତି ତଳେ 816 କେଜାଣି ଏଟା ଆର କି हाँ 816 ସ୍କୋୟାର ଫିଟ୍
ରୁଦ୍ରପୁର ମେନସନ ହେଇଛି ଖାତା ନମ୍ବର ମେନସନ ହେଇଛି ପ୍ଲଟ
Plot
ନମ୍ବର
number
ମେନସନ ହେଇଛି ଆଉ କୋଉଟା ଛାଡିଛନ୍ତି କେବଳ
ଏରିଆ ଛାଡିଛନ୍ତି
ଏରିଆଟା ହଉଛି 313 ନା
3 ଏକର 13
3 ଏକର 13
he has a 50% share because 2 persons are
ହଁ
purchased.
ହଁ ତିନି ଏକର 13 ଟାକୁ ଯଦି ଡିଭାଇଡେଡ ବାଇ 2 କରିଦବା
ଦେଢ ଏକର
ଏଇଟା ଆସୁନି କି 816 ଯୋଉଟା ଲେଖିଛନ୍ତି ସେଟା
1 ଏକର 56 ଡିସମିଲ ହବ एवरेज
ସ୍କୋୟାର ଫୁଟ ଏରିଆଟା ମେନସନ କରିନାହାନ୍ତି ଠିକ ସେ କହୁଛନ୍ତି ଏରିଆଟା ଟୋଟାଲ ମେନସନ କରିନାହାନ୍ତି
एरिया टा टोटल मेंशन
ସେଟା ଦରକାର ଏରିଆଟା ମେନସନ କରିବା ବୋଲି
ଆଜ୍ଞା ପୁରା ରହିଲା
ଆଚ୍ଛା ରେସିଡେନ୍ସିଆଲ ବିଲ୍ଡିଂ ଇନକ୍ଲୁଡିଂ ଆପାର୍ଟମେଣ୍ଟ ଲୋକେସନ ସର୍ଭେ ନମ୍ବର
ସବୁ ରହିବ तले रहिला सेठी तले एरिया टोटल मेजरमेंट इन स्क्वायर फीट
ଏରିଆ ପାଇଁ ତ ଗୋଟେ ସ୍ୱତନ୍ତ୍ର କଲମ ରହୁଛି ହଁ ତେଣୁ ଉପରେ ଯେତିକି ନମ୍ବରରେ ସେଇଟା ଦେଖେଇବେ ତଳେ ସେଇ ନମ୍ବରରେ
एरिया
ରହିବ
केते
ହଁ ତାର
आज्ञा
ଏଠି ଏଇଟା ମତେ ଯାହା ଲାଗୁଛି ଏଇଟା ହଉଛି ମେଟ୍ରୋ ସ୍ୟାଟେଲାଇଟ ସିଟିର
आज्ञा
Sir, my lord,
ସେଟା ହଉଛି ମୌଜା ରୁଦ୍ରପୁରରେ ଅବସ୍ଥିତ
this property belongs to Metro Builders Orissa Private Limited.
ନାଇଁ ନାଇଁ ଏଇଟା ଆପଣ ଲେଖିଛନ୍ତି ମେଟ୍ରୋ ସ୍ୟାଟେଲାଇଟ ସିଟି
satellite
ତଳେ ହିଁ
city.
ଲେଖା ହେଇଛି ତେଣୁ ସେଇଟା ମେଟ୍ରୋ ସ୍ୟାଟେଲାଇଟ ସିଟିଟା ହଉଛି ରୁଦ୍ରପୁରରେ
Rudrapur.
ଆଚ୍ଛା ତାର ଖାତା ନମ୍ବର ହଉଛି 345 ପ୍ଲଟ ନମ୍ବର ହଉଛି 414 ହଁ
ଏଟାକୁ ଡେଭଲପ କରିଛି ମେଟ୍ରୋ ବିଲ୍ଡର୍ସ
ଠିକ ଯେ ୟାର ସିଏ ତାଙ୍କର ପ୍ରଶ୍ନ ସେଗୁଡା ନୁହେଁ ତାଙ୍କ ପ୍ରଶ୍ନ ହଉଛି ଆପଣ ଏତେ କଥା ଦେଖେଇଲେ
ये सेल डीड रे से किणिचंती
हाँ।
but he has not disclosed in this affidavit in form 26
ये सेल डीड रे सर इतरे मैनेजिंग डायरेक्टर को पावर टून दिया इतला मैनेजिंग डायरेक्टर तापरे दुई जन डायरेक्टर को नारे याको रेजिस्ट्री करला पर कंपनी को दिया हला फॉर डेवलपमेंट कंपनी डेवलप करला पर गोटे फ्लैट मते मिलथिला से फ्लैट ता मोइ शो करछि आउट ऑफ 100 केते फ्लैट्स हम गोटे फ्लैट ता पाइथिलु शो करछि तेणु वी हैव नॉट मेंशन द लैंड ये बिकॉज़ लैंड ता अनडिवाइडेड राइट्स ट्रांसफर हेला समस्त पाखु ओनली फ्लैट जेमति अलगा जगह शो करछि एति मते शेयर
ଖାଲି ଫ୍ଲାଟ ନମ୍ବର ସେଇଥିପାଇଁ ଦେଇଛନ୍ତି ତାମାନେ ସେଠି ଆପଣଙ୍କର ଯୋଉ ଫ୍ଲାଟ ଟା ମିଳିଥିଲା ତାର ନମ୍ବର ହଉଛି A108 in the first floor so other flats the other owners are there so only that particular flat which you get in that metro satellite city that you have mentioned
and plot number and
plot number खाता number सेटा तो अछि सेटा तो गोटे combined रे सब गुडाक flat सेही particular खाता अंडर रे थिबो तो आपण कोन छाडी चंदी बोली प्रश्न पचारुछंदी
ने से तांगर टे कंफ्यूजन हो सर मु बुझी गली ताकर
कोन कंफ्यूजन नै
सुन कोइ दिए
कोन तो
कोर्ट को टिके
हां आपण को
एतिरे माइलट आमे नेइथिलु जण पछि बंशीधर पुस्टिंग टू पावर टनी
इंडिविजुअल
तापर तांकर बोधे इल हे गले ना कोन हे पावर डेथ हे गले पावर टनटा पुणी हे गले लेगी आला हॉस्पिटल जीव को जा मने पड़छि को लॉन्ग बैक कथा एटा 20 वर्ष तल कथा तो आमे ताकू 2 जन डायरेक्टर नारे ट्रांसफर करी अगेन कंपनी को दिया है कंपनी ताकू डेवलप कर सो से इन बिटवीन डॉक्यूमेंट्स स्टार्टिंग से कहउचंती यार आगो डॉक्यूमेंट्स की पछो डॉक्यूमेंट्स शो कराई जो पे कंफ्यूजन क्रिएट होची कंपनी डेवलप करला परे मो नारे जो फ्लैट टा करथि सेटा शो करछि 2019 से
Please put the question once again.
My lords can see at page 22 of this document. A property मोहम्मद मुकीम एवं पीयूष धारी महांती इंडिविजुअली जॉइंटली नहीं थे कंपनी दे हैव नॉट परचेज दिस प्रॉपर्टी एज ए डायरेक्टर ऑफ एनी कंपनी
Is 20
ये जो 82 ऊपर मार्क है नेम ऑफ द भेंडी मोहम्मद मुकीम son of late MD Naik, age 41 years, address दिया है Then the next page, my lord. Name of the Bhendi, Piyush Dhari Mahanti, son of his details has been given. So this property has been purchased. आगे कौन तो ये property आपण आउ पीयूष धारी महांती मिसी के किणी थले
ना
ताले सेल डेटा मिछ
Sir, my lord, managing director of a company निजे निज नारे प्रॉपर्टी ट्रांसफर करि परिबो नाही देयर इज अ लॉ तेणु कंपनी ट्रांसफर कले दु इंडिविजुअल डायरेक्टर को नारे तापर इंडिविजुअल डायरेक्टर परवर्ती अवस्था रे पुनी कंपनी को आउथरे पावर देले पीयूष धारी मानती को टू एग्जीक्यूट दी वर्क
It's not a fact that under exhibit EZ, this it's not a fact that under cell deed exhibit EZ, myself and Piyush Dhari Mahanti, PEEYUSH, ठीक है छाड़ीगिनी DHARI, ठीक है छाड़ीगिनी Mahanti, हला purchased the property mentioned property description को दिया जाते रे EZ रे
एटा रहेगा पेज 84 है
84
description of scheduled property
अच्छा property mentioned under the heading of description of the scheduled property
सेल डी डेट के बेस पे
21/10/2006
सेल डी डेटा एटा केबेकार सेल डीटा अधा देखा जाउनी सब रिवील
जेरॉक्स सर्टिफाइड
2006 ର ସେଲ୍ ଡିଡ୍ ଟା 2019 ସ୍ଟାର୍ଟ ଥିଲା ସେଟା ଆମ ନାରେ କନଭର୍ଟ ହେଇଯାଇଥିଲା ଫ୍ଲାଟ୍ କୁ ଏଟା ଡେଭଲପ କରାଯାଇଥିଲା कंपनी ସେଟା ସେଟାକୁ ରିଫ୍ଲେକ୍ଟ କରନ
this particular property was developed by the company and one particular flat in the first floor
flat number
that is flat number that is I flat number A108 was allotted in my favor in the metro satellite city by the company ଆପଣଙ୍କର ଜାଣିଦେଲା ନା metro and accordingly I have reflected the same in my affidavit ଏସି ଯୋଉ କଣ 40 କେତେ ଯୋଉଟା
Inform 26.
inform 26 in ଏଇ ଯୋଉ 43 ଗୋଟା ଲେଖୁନଥିଲା ସେଗୁଟା ନେଇ ଆସ ହଁ in my affidavit in form 26 exhibit 43 it's not a fact that I have made false declaration with respect to the property in metro satellite city. It's not a fact that I made false declaration with respect to the property in metro so and so. Yes. ଟିକେ ତଳ ଇଏ କରନ୍ତୁ ପୁରା ପଢି ଦିଅନ୍ତୁ ସେଣ୍ଟେନ୍ସ ଆଉ ଟିକେ it's not a fact that under the sale deed so and so myself and one so and so purchased the property mentioned under the heading of description so and so of the scheduled property. This particular property was developed by the company and one particular flat in the first floors, that is flat number so and so, was allotted in my favor in the metro satellite city by the company, and accordingly I have reflected the same in my affidavit in form 26 exhibit. It's not a fact that I have made false declaration with respect to the property. Yes.
Mutim Babu, a property ଶାନ୍ତିଲତା ପୃଷ୍ଟି, ଶ୍ରୀକାନ୍ତ ପୃଷ୍ଟି, ସାବିତ୍ରୀ ପୃଷ୍ଟି, ମାୟାଧର ପୃଷ୍ଟି, ବଂଶୀଧର ପୃଷ୍ଟିଙ୍କର ଥିଲା। ସେ ଆପଣଙ୍କୁ ଏଜ ଏ ମ୍ୟାନେଜିଂ ଡାଇରେକ୍ଟର ମେଟ୍ରୋ ବିଲ୍ଡର ଓଡ଼ିଶା ପ୍ରାଇଭେଟ ଲିମିଟେଡ କୁ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ଦେଇଥିଲେ ଟୁ ସେଲ୍ ଦ ପ୍ରପର୍ଟି।
ଏଇ ଯୋଉ particular
ଆଜ୍ଞା ଆଜ୍ଞା ସେ ଯୋଉ ପେଜରେ ପେଜ 81 ରେ ଅଛି ଉପରେ
81
ଉପରେ ଭେଣ୍ଡର୍ସଙ୍କ ନାଁ ରହିଲା ନେମ୍ ଅଫ ଦ ଜେନେରାଲ ପାୱାର ଅଫ ଆଟର୍ଣ୍ଣି ହୋଲ୍ଡର ଫର ଭେଣ୍ଡର ନମ୍ବର 125 मोहम्मद मुकीम मैनेजिंग डायरेक्टर मेट्रो बिल्डर प्राइवेट लिमिटेड।
वेंडर नंबर 125 हां
दिस इज सेल डीड ऑफ 2006 ଆମେ 2019 ର ଡିସ୍କସନ କରୁଛୁ ନେସନ ଏଣ୍ଡ 2006 2019 ଭିତରେ ପ୍ରପର୍ଟି ଅଲରେଡି ଟ୍ରାନ୍ସଫର ହେଇକି କମ୍ପାନୀ ନାଁରେ କମ୍ପାନୀ ତାକୁ ଡେଭଲପ କରିଦେଲା ଏବଂ ମୋ ନାଁରେ ସେୟାର
ଗୋଟେ
ଶୋ କଲି ଏଥିରେ ୟା ବିଷୟରେ ଆଉ କଣ ଡିସ୍କସନ
you have filed this document
ମୁଁ ଫାଇଲ କରିଛି
ଆପଣ ଯୋଉ କମ୍ପାନୀ କୁ ତାହେଲେ ଟ୍ରାନ୍ସଫର ହେଲା ସେ ଡକ୍ୟୁମେଣ୍ଟ କାହିଁକି ଦାଖଲ କଲେ
ମାଇ ଲର୍ଡ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଯେ ୱିଟନେସର ଅଛନ୍ତି ତାଙ୍କର ପ୍ଲିଡିଂ ରେ ବି ପ୍ଲିଡିଂ ସବୁ ଜିନିଷ ମତେ ପ୍ଲିଡିଂ
ମୋ ପ୍ଲିଡିଂ ଆଜ୍ଞା ଦରକାର ନାହିଁ ଆପଣ ନିଜେ ଦାଖଲ କରିଛନ୍ତି ଏ ଡକ୍ୟୁମେଣ୍ଟ
ଆମେ ତାକୁ
ମୋ ଡକ୍ୟୁମେଣ୍ଟ ନୁହେଁ ଏଇଟା
କରିବା ପାଇଁ ଯେ ଆମର ବି କିଛି ଡକ୍ୟୁମେଣ୍ଟସ ଆମେ ଦେଇଛୁ ଯେ ଏ ଭୁଲଟା ଆପଣ ବି କରିଛନ୍ତି ଆମେ ବି
it's all right
not related to this
room lekon exhibit EZ is the cell is a cell deed of the year 2006 हाँ केवे
31/10/2006
पूरा डेट लिख दो ईयर काट दो ये सेल डीड और डेटेड कर दो सेल डीड डेटेड ऑफ लग सेल डीड डेटेड कर दो है ना डेटेड 31/10/2006 and it was developed by the company and when I filed nomination in the year 2019 for the election in question, comma, at that point of time, one of the flats one of the flats at that time at that point of time at that point of time comma at that point of time one of the flats that is flat number A108 in the first floor of से जो कौन मेट्रो सैटेलाइट सिटी एटा इन्वर्टेड कौन भीतर was allotted to me which I have reflected in my affidavit, so and so, and I didn't feel any necessity to mention the other details of the sale deed by Exhibit EZ.
My lord, kindly record my objection.
About that, not there in the pleading.
ମାନେ ଆଜି ଯାହା paragraph continue କଲେ beyond pleading and amounts to fishing and roving inquiry.
ସରି ଯାଉ ସାର୍ ଏକାଥରେ ଲେଖିଦେବ।
ସରିଲା ତ 4:15 ହେଲା।
ଆଚ୍ଛା ତ ଆଚ୍ଛା ଲେଖିଦିଅନ୍ତୁ ସେ ଯୋଉ ସେଠୁ କପି କରି ନେଇ ଆସନ୍ତୁ କି କୋଉ କୋଉ ପାରାଗ୍ରାଫ ଆଜି ଯାଇଛି ଆଜି
ଗୋଟିଏ ଲାଇନ
ଆଉ ଗୋଟେ ପଚାରିଦେବେ କ୍ୱେଶ୍ଚିନ୍। ଆଚ୍ଛା
ଆପଣ ଏ ପ୍ରପର୍ଟି ଯୋଉ କମ୍ପାନୀକୁ ଦିଆ ହେଲା ଡେଭଲପମେଣ୍ଟ ପାଇଁ ତାର କୌଣସି ଡକୁମେଣ୍ଟ କାହିଁକି ଦାଖଲ କରିନାହାନ୍ତି କାରଣ ବତେଇ ପାରିବେ?
ଏଇ ଯୋଉ ଇଜେଡ୍ ର ପ୍ରପର୍ଟି
ଇଜେଡ୍ ର ପ୍ରପର୍ଟି
ଯୋଉଟା କି ତାଙ୍କୁ ପାୱାର ଅଫ ଆଟର୍ନି
original landowners gave power of attorney to the Metro Builders. He as a managing director of Metro Builder executed sale deed in his own favor and favor of that Piyush Dhari Mahanti. And now he is saying this property was transferred to the company.
ସେ ଯୋଉ ଆପଣଙ୍କର ପ୍ରଶ୍ନ ହଉଛି କଣଟା ଯୋଉ
कंपनी को जो डेवलपमेंट ପାଇଁ ଦିଆ ହେଲା ତାର ଡକୁମେଣ୍ଟ କାହିଁକି ଦାଖଲ କରିନାହାନ୍ତି?
କମ୍ପାନୀର ଡେଭଲପମେଣ୍ଟ କୁ କିଏ ଦେଲା?
ସେ କହୁଛନ୍ତି କମ୍ପାନୀ କୁ ଦେଇଦେଲେ
ମାନେ ଇଏ ନିଜେ ଦେଲେ।
ସେ ଯାହା କହୁଛନ୍ତି ସେ
ଦେଲା ପରେ ପୁରା କମ୍ପାନୀ ଯାହା ଦେଲା ମୁଁ ତାକୁ ରିଫ୍ଲେକ୍ଟ କଲି।
ମୁଁ ଆପଣଙ୍କୁ ଦବା ଆପଣ
ତାର ସେଇ ଯୋଉ ଡକୁମେଣ୍ଟ
ସେ ତ ଶହ ଡକୁମେଣ୍ଟ ଦବା କୋଉଠି ଆପଣଙ୍କୁ ସବୁ ତ କମ୍ପାନୀ ଡକୁମେଣ୍ଟ।
ଅଲରାଇଟ୍ ଏଇଟା I have not filed any document ଲେଖିଦିଅନ୍ତୁ I have not filed any document to show that the company was entrusted. कंपनी माने को कंपनी?
मेट्रो बिल्डर्स।
मेट्रो बिल्डर द कंपनी मेट्रो बिल्डर्स से लिखो पूरा लिख दो मेट्रो बिल्डर्स ओडिशा ब्रैकेट ओडिशा लिख दो
ओडिशा
ओ आर आई प्राइवेट लिमिटेड I have not filed any documents to show that the company so and so was entrusted as a limited for a inverted commerce surround limited for said surround was entrusted to develop the property
purchased under exhibit EZ
purchased under sale deed purchased under sale deed exhibit EZ ହେଲା
ଏବଂ ଆପଣଙ୍କୁ ଯୋଉ ଫ୍ଲାଟ କହୁଛନ୍ତି ଆଲଟ ହେଲା ତାର ବି ଆପଣ କିଛି ଡକୁମେଣ୍ଟ ଦେଇନାହାନ୍ତି।
ଆଲଟମେଣ୍ଟ ଇଏଟା ଅର୍ଡରଟା ଯୋଉଟା କହୁଛନ୍ତି କମ୍ପାନୀ ଆପଣଙ୍କୁ ଏଇ ପର୍ଟିକୁଲାର ଫ୍ଲାଟଟା ଦେଲା ତାର ମଧ୍ୟ କିଛି ଦେଇଥାନ୍ତି ଡକୁମେଣ୍ଟ।
affidavit mention କରିଛି ନା sir?
All right. It is a fact that I have not filed any document to show that the flat number that flat number A108 of first floor in Metro Satellite City was allotted in my favor. Stop. अच्छी ऑब्जेक्शन रेडी अच्छी बंद करिबा जी एटा से मु कर दो जी द क्वेश्चंस पुट इन पैराग्राफ नंबर से 97 ठीक है were objected by these ones on the ground that the seta cartesian same are beyond pleading
and amounts to fishing and roving
ठीक है सेटा थाओ and amounts to
these questions my lord I have asked on their own document they have filed.
All right it is a question of amounts to fishing and roving
inquiry.
All right so to be continued देखी दियो खाली कर दो
सर फ्राइडे सर
कौन है
फ्राइडे
दी दिन आगे जब देवे एकदम क्लोज कर दो
कौन क्लोज कर देवे
मंडे क्लोज तापर असेंबली स्टार्ट
मंडे क्लोज करिवा
मंगलवार
आपण दीटा डेट रे सार देबे
ମୁଁ
कहू
ଦିଟା ଦିନର
ताले सार दूना दी सप्ताह सर जांदा काहे के ओटा गोडौचन ये तो दौज वर्तमान ओपन कोर्ट इज टेलिंग दैट यू विल क्लोज ड्यूरिंग दिस वीक यू विल बी फ्री देयर आफ्टर सो काली गोटे काली गले अच्छा पर दिन ता पर दिन ठीक अछि पर दिन हला गुरुवार गुरुवार और शुक्रवार आपनकर टाइम ता तो रहउछि आपनकर 3टा बळगु ना तणु सो लेट अस कीप इट
4:30 हेगा
हाँ किसी असुविधा नहीं जदि एमती आ 15 मिनिट एक्स्ट्रा आइयो किसी असुविधा नहीं सो कीप इट ऑन 14th September 2023 at 3 o'clock right okay ये खाता का